Any inclusion? Just hand over the slip. Yes.
Lordship, if I may grant a leave Lordship to file a MAT without certificate of Lordship.
When was the order passed?
11th July Lordship. But I know the
11th July.
I just know the matter in 23rd of October.
You are not a party to the proceeding.
Party but not served Lordship.
Have you applied now?
Yes, Lordship. Yes, already applied.
Granted.
Grateful.
Mention is for upgradation because the accused petitioner's mother is seriously ill.
No, madam, sorry. Next. Yes, call the list.
Number 1. I am appearing for the aspirant Lordship. Earlier there was direction to serve. Service was not affected Lordship. I will take it up in the next circuit. But Lordship, the defect may be removed. I have already filed the section 5 application.
On the prayer made by learned advocate, on the request, learned advocate for the appellant, let this matter stand over till the next circuit.
The defect.
Defect, it doesn't mention defect.
It is not shown as defective.
Not shown.
Not shown as defective.
Not shown.
Earlier there was. Item number 2.
Yes, why to be mentioned?
It's the last time. Mr. Jani is appearing on the appearance.
My lord,
Why
yesterday
doing
this
it?
matter was taken up, my lord. There is an application for condonation of delay. My lord, about 90 days, my lord, I have stated, explained, my lord, paragraph 3 and 4. My lord,
Oh, I
this is the. Yesterday it was taken up.
Yes, have you served?
Yes.
Yes, yes. My on learned government pleader was appearing in the on behalf of the state.
Oh, Mr. Chaudhary
Yeah.
was there, na?
My land was occupied by for the purpose of construction of Sidar Bandh. My lord, without any compensation, my lord, the district magistrate, my lord,
Moon canter, which can?
Can one is that delay?
Can one.
One is the delay.
Can one, my lord, the section 5 application.
You sure? Have you filed affidavit of service? No.
Yes.
Affidavit of service filed in a section 5 10 can one. Affidavit of service filed in court today be kept with the records. Stop in spite of service, nobody appears for the respondents. Paragraph, this is an application for condonation of delay of whatever, 90 days in presenting the appeal. Stop, causes shown being sufficient, the delay is condoned. Can 2 is disposed of. List the appeal and the stay application
Appropriate order.
and the application for appropriate order before the next circuit.
My lord, kindly take up this matter on Thursday.
Sorry.
Sorry.
Yes,
Item number 3, under the petition on office of correction,
yes.
instead of special court indicates at Jalpaiguri, it should be Alipur.
Esho? Let the let the order dated November 7, 2024, be corrected by substituting Alipurduar instead of Alipurduar within court, or instead of within court, special court, bracketed under NDPS Act, bracket closed, first court. Oh, no, sorry. By substituting Alipurduar in the place of Jalpaiguri, just actually.
Not the first court, only Alipur.
Acha, in the place of first court Jalpaiguri.
Special court NDPS Alipur.
In the place of first court জলপাইগুড়ি ওইটা চলে যাবে, ফার্স্ট কোর্ট জলপাইগুড়ি চলে যাবে, খালি আলিপুরদুয়ার, বুঝতে পেরেছো? Let this correction be incorporated in the order.
For this petitioner, mother, instead of additional, it will be chief judicial magistrate.
আচ্ছা ওইটা শোনো, আরেকবার পড়ো তো।
It's ordered, it is the November to hunting would be current by instead of.
In the place of
Take of possible, because by.
জলপাইগুড়ি, in the fifth paragraph of the order. তারপরে let this order be. Chief Judicial Magistrate,
Coachbihar. The bad.
let the order dated November 7, 2024 be corrected by deleting the word additional, the capital A within, just additional should go,
Yes.
additional in paragraph 6 of the order. Stop. In other words, the bail bond and surety should be to the satisfaction of the Chief Judicial Magistrate, Coachbihar. Paragraph, let this incorporated.
So 5, 6, 7.
7.6 service has not been completed. I will pay for next 7.
Which one? 7?
7.
On the prayer made by learned advocate for the restoration application.
On the last petition service was directed. but
Acha.
service has not been done.
Learned advocate for the petitioner says that service is yet to be effected. Stop. On his request, let this matter be listed before the next available circuit bench.
Eight, I'm for the appeal. I'm for the. Yesterday, my lordship denied to entertain me at 11, and today destiny has clocked in such a way that before 11, I'm before my lordship. But the matter pertains to my dismissal of writ application, the revenue matter. The order, my lord, consists of only 4 lines, and the first 3 lines are before challenge before my lordship. In the first line of the 11 report holds that this court does not sit in appeal over the order of the appellate authority. Now, this in my humble submission my lordship, is not correct. If I can have my lordship on the scheme of the act, my lordship.
Yes, your writ
That's
petition, hang on. Your writ petition has been dismissed more than 1 year ago. Appeal has to be heard out. Appeal has to be heard out, file requisite number of informal paper books if you so like, right? This appeal is directed against a judgment and order dated.
Later details, let them make a lot of affidavits করে দিলেও করা যায়। এই দু লাইন এটা কোনো ফাইনালিজম দরকার রেমিট ব্যাক করে দেওয়াই ভালো।
What would you like? Would you like this order can't be sustained? There's nothing in it.
Well, the only ground was that non-production of the original invoices.
No, question is
Would
this
you-
writ
would you-
order is not a reason order.
Would you like a remand?
Let it be heard by the.
It's not a recent order.
Anyway, let it be heard.
Then let it be, let there be a remand, let it be heard upon affidavit,
Lordship,
upon affidavits if.
order doesn't
It can be
explain.
kept for the division bench. My lordship
It has to be before the single bench. It has to be-
No, we'll set it aside,
Set it
we'll
aside.
send it back. This appeal is by consent of the parties. The appeal and the connected application are taken up for hearing together. Paragraph, this appeal is directed against a judgment and order dated August 14, 2023, passed in WP number 583 of 2023, comma, being a writ petition filed by the appellant herein. Stop. The order impugned reads as follows. এই যে পুরোটাই দেবে 5 লাইনের অর্ডার, বুঝেছো? Paragraph. The appellant says that the order is completely unreasoned. Stop. We have to agree to that submission. Stop. We are of the view that this order cannot be sustained and there should be a remand to the learned single judge for fresh hearing. Paragraph. Learned advocate for the respondents,
Just one.
comma, in his usual fairness, comma, leaves the matter to the discretion of the court. Paragraph. The order under appeal is set aside. Stop. The matter is remanded to the learned single judge having determination to hear the matter, comma, if necessary. Should we direct exchange of affidavits? Do you want to file affidavits?
Small issue.
If necessary.
May not be necessary.
If necessary, upon exchange of affidavits. That is all. Paragraph. The appeal and the application stand disposed of.
Thank you.
হ্যাঁ? Application নেই? Reflex তো করছি না, রেকর্ডে আছে কিনা দেখো না। এত মোটা কি সব?
There was an application earlier, it was a restoration application that has already been allowed.
So there is no pending application?
No pending, I believe there is no pending application. There was a restoration.
There is only a can for modification or setting aside of the order, appropriate order can is only.
Appropriate order can is there.
Is there.
ওই তো ওইটাই তাহলে।
That also stands.
হ্যাঁ,
Not.
বইটা ও দিয়ে দিয়েছো? Now that you have handed up the book, it has become an exhibit. How can we return?
No, not.
There is
There is no doubt.
9, 10, 11.
Mr. Mukundar was supposed to take instruction. This matter was heard last Friday, Madam. I'm led by Mr. Basu in this. That
Justice Krishna Rao. Justice Krishna Rao.
No, sir, termination was challenged, Madam. When Madam.
Whose order?
Madam, Justice.
না ওটা তো ব্যাংক কত
ওটা ব্যাংক কত?
ব্যাংক কত
তুমি কোনটা লিখে বলছো?
ব্যাংক কত কৃষ্ণা হবে ওটা তো জজমেন্ট কিছু দিয়ে দিলি ছেড়ে দিয়ে
Chandos,
Justice?
Chandos of. Kaushik Chandra.
চন্দ্র শর্মা ও জাজমেন্টে রিলাই করে ও কৌশিক চন্দ্র
This one was heard.
Justice Chondo. Oh, okay. So what shall we do? We'll pass it over. What can we do? Pass over.
13,
চলো চলো চলো
14, 15, 16,
15 appellant? নেই।
Yes, the 16 hours appellant.
Who is for the respondent?
State.
17,
You have condonation application?
That is the deal.
Have you served?
Yes, we are.
Let us come back in the second call. Let us see.
17, 18,
Item number 18, bring for short passover.
19,
My, come for the state.
The Panchayat Pradhan was to file a report in compliance of the order dated 25th of September 2024. Yesterday.
Yes, he
Yes, my
appeared.
lord.
He appeared yesterday.
Yesterday he appeared, the earlier occasion he did not, before that he did. On the first occasion, his submission was, report was final, prepared. Yesterday, I don't know what he said.
He said it's a tentative report, preliminary report, something like that.
Something like that.
Tell us,
Yesterday,
what do we do? We pass it over. Let us come back. What
Yes, sir.
can we do?
Passover, Pradhan nahi. No, cannot.
Who was the learned advocate? Try to contact him if you can.
Supratim, he was here. We had even served him notice, my lord.
Try to contact him.
I will.
Raku.
21, I appear for the plaintiff.
Both sides are here.
Yes, Mr. Majumdar is there. He's the one who is.
Mr. Mujumdar.
Yes, sir. The matter not pertains to the Sashastra Sima Bal. The appellant herein was appointed as a
But
constable general.
your petition was dismissed.
No. The writ petition has, there is an order in the writ petition. I am aggrieved by the order, my lord.
Interim order.
No, final order.
Petition has been dismissed, my lord.
Dismissed.
The writ petition was dismissed.
That's what I
Ultimately,
said.
in the final order it was dismissed. Yes. I am against that order.
Then the appeal has to be heard again.
The paper book is there, my lord. There was
Paper book is ready.
there was direction for paper book, my lord. The paper books are there. Paper book is there.
Very well. Let us pass it over, because in the first call, we have passed over certain matters. We should take them up first. Pass it over.
And for the appeal and repetition, if it was dismissed, I challenge the order. This is a washing of the affair, my lord. The defector complaint did not turn up before the writ court also. The last time you lost it, like me, serve again. I serve, but I see that the postal receipt, it has not been sent to his.
So not yet available. Proof is not yet available.
But earlier this is returned back unclaimed.
Right. Very
So
well.
you also tell the state is here. So when you hear this matter, because the point of law is only.
Sure. Without them, we'll hear this matter.
No. Why I said, I know my name, sir. Principal judge, but he did not turn up.
See,
The request did not turn his point
see
of peace.
Tomorrow, if you can produce the proof of service, not today.
22.
22 companies. Additional advocate general.
Yes, Mr. Chaudhary.
But the last week, already I have concluded my argument with parties.
Yes, Lordship expressed that.
Allow me to complete then.
Oh, this is that one. Of
That one,
course.
my lord.
Yes,
The-
yes.
Without the scope of the,
Yes, yes.
the learned trial judge.
Lordship expressed to decide to file the return note, Lordship.
No, not necessary. We had expressed, not necessary. We'll dictate it.
Yes.
No, not necessary. I would only like to see the earlier writ petition, Mr. Chaudhary.
My lord,
What was the scope of that writ petition
my lord.
and the order passed by the learned single judge
yes,
on that writ petition?
yes,
Against
yes.
which the appeal was.
yes.
These are the two things. Kindly ask your junior to supply.
My brief.
Once you give us those two, we will just consider and come back tomorrow in court and dictate.
Lordship.
Hearing is concluded. For orders, it will be listed.
Lordship.
But in the course of day or in the...
My lord, may I hand over, my lord?
Yes, yes. It's not a part of the stay petition, no?
No. Because it is a separate proceedings.
Ah.
Lord, I'm sorry, Lord, I have one copy, Lord. Can I? I have a.
No, do this. Ask your junior to make a Xerox
I will do
copy
that, my lord.
and as soon as possible to file it. Give it to me.
Read copy is also one, my lord. Because it is a voluminous copy. My lord,
Give us one copy only.
so grateful, my lord. Sorry, my lord.
No. No, we are going to keep it.
Yes, yes.
We are going to keep it. Eta we file এর সঙ্গে রাখো. And the order passed by the learned single judge? That is all. This is for the sake of completeness.
Yes.
We will consider this today.
Yes.
Tomorrow, list it as 4 orders at 1 o'clock.
Lordship.
Yes.
Will you be available? Your presence may not be necessary. We have indicated our mind.
But I am here only.
For orders marked 1 o'clock. Hearing is concluded. Lekho. Hearing is concluded for all practical purposes. Stop. Paragraph. All practical purposes. Concluded. Stop. Paragraph lists the matter under the heading for orders on such and such. Kalki date thou. Marked 1 p.m.
Grateful.
Shunun, আমার চেম্বারে পাঠানো।
Number 23. 24.
24 other side is there.
24, my lord. 23.
20?
23. Yes, most part.
Yes, your writ petition has been dismissed.
Yes,
File paper books, appeal will be heard.
this is short, very short issue, Lordship.
File informal paper books. Likhe now. The appellant's writ petition has been dismissed. Stop. The appeal has to be heard. Stop. The appeal is formally admitted. Stop. Paragraph, let requisite number of informal paper books be filed, incorporating therein all papers that were available before the learned single judge, as also the memorandum of appeal and what is this application? Appropriate relief.
Appropriate order.
And the application for appropriate order filed before us. Stop. All formalities are dispensed with. Stop. You appear for all the respondents.
Wonderful. State, Madam.
There are private respondents.
No,
No, only state. Since the respondents are represented, comma, notice of appeal is deemed to have been waived. Stop. Paragraph. Acha, paper book within 2 weeks. ওই informal papers টা ওখানে বলে দাও within 2 weeks. Time period টা বলে দাও. Paragraph. Liberty to mention once paper books are ready. Paragraph, the application being can such and such stands disposed of.
So can, Lordship, may I humble submission, Lordship, an interim order to the extent that my license has been suspended for indefinite period of time. Therefore, my trade is right now closed. Only the interim license because we may be renewed or we allowed
There is
so
a
that I can
specific
continue my trade.
Since there is a
Meanwhile,
specific provision for appeal,
Lordship,
that
no,
is the reason.
I have invoked, Lordship.
Dismissal
Why
of
I am telling Lordship? Because meanwhile, during the pendency of this application, Lordship, the respondent has already taken the money for renewal of my license in 2 occasions. But despite once indefinite suspension is going on the contrary, they have taken the renewal fees. Now, this is the whole issue.
একটা খালি দেখে দাও তাহলে ক্যানটা dispose of করার আগে. Pendency of this appeal will not stand in the way of the respondent authorities renewing the license of the appellant in accordance with law. তারপরে ক্যানটা dispose of.
I am the respondent below here.
Appellant is-
25.
Appellant নেই তো.
26.
You are.
My lord, item number 26, I am appearing for the respondent, writ petitioner.
Which
Lordship, this matter, Lordship, may be heard in physically, Lordship, I need to go there. That is the prayer, Lordship, today.
Which one?
Kindly accommodate me, Lordship.
20 has not been called on.
So you are in 24.
Oh, Lordship, this is 26.
You
I
are
am-
in 24. Virtual hearing will never work, Mr. Chaudhary.
Just a second, Mr. Das, for a second. Yes.
Yes, which one?
Well,
24?
24, I am the respondent here.
Yes.
25th, fifth also, I am the respondent.
Very good.
The appellant is not here.
Then we will pass it over or adjourn it till next circuit, whatever.
That is, if they have chosen not to, what
Yes.
can I do?
We are passing over in the first call all matter. Let us pass over. 26, Daku.
25.
Same.
25, I'm with respect to 7, 8, and 9.
Very well.
Original.
Pass over.
26.
26,
You are for the?
appellant.
My lord, I am for the respondent, Lordship.
They are asking for
I-
accommodation. He says he wants to come and do it physically.
Then
Yes,
kindly
my lord.
of my difficulties, what is the urgency, my lord? There was an FIR, my lord, which has been registered on 13th September. And by an order of 20th September, after 7 days, it has been stayed, despite disclosing the cognizable offense, and we could not investigate. This is our challenge. The, my lord, if it is not today, tomorrow or my lord, Thursday. My lord, this is my only.
Lordship, kindly make it in next week,
Lordship,
Lordship, any day, Lordship. Instead of making it on Thursday or tomorrow, kindly make it on Monday, Lordship. I am ready to come and argue this matter, Lordship.
Monday.
I have no difficulty on Monday if it is taken
So
up, Lordship.
Chatterjee, where is the circuit on Monday? Is he leading you?
I'm late. then.
Lordship, yes, my lord, I'm
There
leaving
is no
because
circuit on Monday.
Either today or next circuit, 25th.
Come
Lordship, in
tomorrow.
that case, Lordship,
No, this is then we'll pass an interim order. What is this?
no, Lordship, kindly consider my predicament, Lordship.
What predicament?
Lordship, they do not have the urgency, Lordship. I am ready to apprise your Lordship. I can ready to argue this matter. If your Lordship kindly fix it on any day, Lordship. This 2 day, Lordship, it's quite difficult, Lordship. If your Lordship wants, I can come. But
Come.
Lordship, the only difficulty, I am having some difficulty for these 2 days, Lordship.
What, you are in court? We can see you are in court. What
I am
difficulty?
in court, Lordship. I am in court. I have been served with the copy only yesterday, day before yesterday. So I could not make the arrangement to go there. That's the only problem. And if the interim order is passed, the interim order will be on the investigation. Investigation is stayed. I challenge their issuance of 35 notice. Lordship, the cognizable
Virtually,
offense.
what is the difficulties through virtual platform you argue? My lord,
Very
my
well. Come tomorrow virtually. Argue tomorrow.
lordship. Yes.
Argue tomorrow virtually.
Lordship, day after, instead of tomorrow, can it be posted on day after tomorrow?
No, it is the last day, Mr. Chatterjee. You have to consider everybody's convenience, not only your own.
Lordship, I bow down to your Lordship. Kindly consider day after tomorrow. I will.
That
I
is
will
the
do
last
matter,
day of
Lordship.
the circuit. We won't be able to take up any heavy matter. Chalo. Tomorrow.
Tomorrow then. Grateful.
27, 28, 29.
29 minute is a minute second appeal for admission. There's a 1 day's delay. That is their minutes for admission. So
No, delay will be considered by the single judge.
single, that's right.
1 day or half day, doesn't matter.
That's the usual practice.
Really. There is a delay in presenting the second appeal. Stop. The condonation of delay application is to be heard by a learned single judge as per practice of this court.
Yes.
Paragraph, let this matter stand released from our list and be placed before the appropriate bench.
Liberty to mention.
Liberty to mention.
Grateful.
Number 30.
Now, there was a substitution of the parties, my lord. We had sent services.
You appear for whom?
The added respondents also. The added respondent service is inconclusive, my lord. We had sent it by post.
Oh, then you have to.
We had sent it.
Next.
There is a caveat.
No. During pendency of this appeal, my lord, 2 of the respondents had expired.
Substitution.
Substitution.
So
was done.
substitution done.
Yes. Thereafter, my lord, in January, my lord, we had sent a notice, but the report is inconclusive.
Learned advocate for the appellant says that service on the added respondents is not complete. Paragraph as requested, comma, let this matter stand over till the next circuit. Stop. In the meantime, let service be completed.
Grateful. May I hand over this affidavit of service or not required?
31. And for the plaintiff respondent, the
Sir,
delay of
for the
3,000 days. That should be heard by the single bench.
This is 31.
Yes.
Lordship.
This is not a second appeal.
No, first appeal. But the problem is that the first appeal also
First appeal, the delay, why should the delay be?
3,000.
Not by us.
Yes.
Yes, where is the appellant?
Lordship, I am the appeal.
The 3,000
You
days.
you wish to file an affidavit to the condonation?
No, they have.
They are what the direction.
Once, maximum, there's no pleadings, but no explanation. I should not, because these are 3,020 days.
3,020 days.
Lordship, I was actually wrongly proceeding before the district judge against the impugned order. So
Let us see.
Actually,
Mr. Roy, 3,020 days, you better file an affidavit.
3,420 days.
No, what is the ground?
Lordship, I was
He was proceeding before the wrong form.
There's no explanation.
That is my
I seen.
section 14 of the limitation.
Section 5 to the.
So you file a supplementary affidavit.
Lordship.
You also know regarding the convention, I'm always, you lordship of the same view. Yeah, man, no explanation.
Lordship, in
It is really between the appellant and the court.
Yes, yes.
The
So it
court
is-
has to be
It is
satisfied
in
that
para
there
number
was
5 of my
sufficient reason.
can is written that I was wrongly proceeding before the district judge and the appeal number is there.
So where is the order of the district judge? Let us see.
So it is with the memo of appeal.
তুমি এটা দেখো ভাই সেকশন 5 টা দেখো এখন তো ডিস্ট্রিক্ট জাজের অর্ডার দেখে
Why the
লাভ নেই।
teacher, there is also delay.
No, yes, where is the order of the district judge? Let us see.
So probably it is not enclosed. I am filing the
So
certificate.
how can you know on what ground the order was
That is
passed?
That's a
the,
pecuniary
on the
jurisdiction,
pleadings is
nothing.
very clear.
Pecuniary on the ground
The
of
delay,
pecuniary
they filed
jurisdiction.
this appeal to the district judge. Subsequently, they have advised that there is no pecuniary jurisdiction. Then route to without leave. And now,
No, where is
No,
the-
it was
let us see.
dismissed. It
Oh,
was
it was
dismissed
dismissed
by
at
the
your-
under district judge
at your,
on for the want of
I
pecuniary.
really-
এই যে maintainability point ইয়ে করেছে, considering the value of the pecuniary
so
jurisdiction.
pecuniary jurisdiction is not there.
Considering the pecuniary jurisdiction, the
They
appeal,
hold the file is, it's a delay.
no, then anyway, that matter was before the court, appellate court.
And then, my lord, it was admitted, then it is dismissed on account of pecuniary.
Anyway, this is a
Then
non-maintainability.
he has not given.
So when the date of the order? When is the date of the order? This is 28/6/2023.
Lordship.
And when this appeal was filed?
This is final.
This was 2007.
18 August 2023.
18th August 2023. Anyway, that is,
No, this appeal is directed against which order?
This is the
District
order passed by the civil judge senior division. And against that order, we preferred an appeal before the district judge. And
Yeah.
district judge negated it on the for the want of
I did
pecuniary
actually the court,
jurisdiction.
what is it? They shoot for partition. I got the decree. So,
Mr. Roy, we are not concerned with the merits.
no, I'm getting.
Where would the appeal lie from
It lies to the High Court.
High Court.
Pecuniary jurisdiction of the Assam that.
division bench?
Yes.
but they're going to.
From the order of learned civil judge senior division?
If this is my lord, 1,50,000, this is Assam, Bihar, the civil court says, so this is my Bengal Assam. So, under the 1,50,000 before High Court, this year said that it's above, so he has, his lordship.
That's good value was 2 lakh rupees.
Then he may have some sort of an explanation, ill-advised or whatever it is.
My always views are I am not.
No,
against all this
28/6/2023, the matter was dismissed as not maintainable on the ground of pecuniary jurisdiction.
But then, my lord, this is delay.
Then how many days?
Then a few days delay.
Month of August, he has filed it.
But this is not directed against
But-
the
but-
district judge's order.
He should get the benefit of section 14.
That's right.
You also can delay.
Hey, issue.
I'm always against it.
There is a delay of
But they will not accept me. I mean, I will argue that every law will be.
3420 days
Section 14.
in filing this appeal. না 3420 লিখো না কারণ স্ট্যাম্প রিপোর্টের অন্য কথা বলছে 2595 days comma as noted by the stamp reporter comma in presenting this appeal against the judgment and decree
I say.
dated yes sir, dated
29th March 2024.
March 31
2014.
14.
2014 March 31 2014
Passing title should number.
passed in title suit number 8 of 2012. Stop. Paragraph. The appellant oblique petitioner says that he was wrongly advised and hence assailed the aforesaid judgment and decree of the learned civil judge senior division, Kuch Bihar, before the district judge, Kuch Bihar. Stop. The district judge dismissed the appeal by judgment and order dated.
This is my notes.
June 28, 2023. Stop. Now, comma. In title appeal number 38 of 2017, comma, on the ground of lack of pecuniary jurisdiction. Stop. The petitioner says that he has now been advised that because of the valuation of the matter, comma, the appeal from the valuation of the suit, comma, the appeal from the judgment and decree of the learned trial court would lie to the High Court. Stop. Accordingly, this appeal has been filed. Paragraph. Mr. Roy, comma, learned senior counsel representing the respondents, all the respondents, comma, in his usual fairness, comma, leaves the matter of condonation of delay to the discretion of the court. Paragraph. Although the delay is huge, comma, we find that there is some explanation furnished by the appellant. Stop. It is possible that he was proceeding bona fide before a wrong forum. Stop. In our opinion, comma, taking a liberal approach, comma, the appellant should be granted the benefit, benefit under section 14 of the Limitation Act.
But there's stay application, there's no scope, like paper will be prepared.
Stop.
There's no scope stay.
Paragraph. Accordingly, we condone the delay and admit the appeal. The কোন can হচ্ছে দেখে না, এটা which can is this? Can 1 stands disposed of. Ever if
Can 2 is a stay application.
if it eaten now or can 2 now. Stop. Now, can 2 of 2023 is an application for appropriate orders.
For a stay.
For stay.
Suit for partition was.
Stop. There is no scope for passing any interim order. Stop. Let the appeal be heard out. Paragraph. Let requisite number of paper books be filed. Let the lower court records be called for.
Yes, fine.
Let the lower court records be called for. Stop. Once the records arrive, comma, the department shall intimate learned advocate on record for the appellant, who shall then prepare requisite number of paper books within 3 weeks thereafter. Stop. Since the respondents are represented, comma, notice of appeal is deemed to have been waived. Paragraph. Once paper books are ready, comma, the parties will be at liberty to mention the matter before the then available circuit bench.
I get one effective order.
Can tutor disposed of.
Lordship, in item number 32, I am for the respondent, Lordship. 32.
Cholo.
Lord, in 33, I appear for the Lord appellants.
I'm for the respondent number 2, my lords.
Respondent number?
2.
What about the other respondents?
Lord, all except 5 and 6 have been served. Lord, in respect to 5 and 6, we have dispatched the notices.
You
Lord,
still don't have proof of service.
Proof of service, my lord. However, my lord, they have been attempted to be served on, Lord, thrice. My lord, but because the same address exists in the, my lord, trial court.
Yes, but then
Lord, I may have to approach for alternate service.
you may have to. So next circuit.
Yes,
What do you want? Learned advocate for the Iraqi 33.
Lord, let the delay be condoned, my lord, 290 days.
We always condone delay, but then serve. First serve. Show us that they have been served. Learned advocate for the appellant says that still the respondent numbers 5 and 6 have not been served. Stop. Now, still, service has still the appellants have not been able to effect service on the respondent numbers 5 and 6. Stop. Paragraph as requested, comma. Let this matter stand over till the next circuit. Stop. In the meantime, let necessary steps be taken by the appellants.
Grateful, madam.
34.
So I'm appealing for the appellant.
Yes, what? Your writ petition has been dismissed.
No, my
No,
lord,
my
this
lord.
is the appeal against the order passed by the London Civil Judge Senior Division.
I see.
Order of status quo in a suit for specific performance.
Suit for?
Specific performance of.
So why what is can one for?
So it is for appropriate orders. Actually, in memo of appeal, I
Suit for specific performance, status quo order pass. This is an interim order,
no lordship, it is a contested order.
contested order.
I have challenged it mainly on two grounds: suppression of material facts and while passing the order, balance of convenience and inconvenience and irreparable loss and injury has not been taken care of by the honorable landed court below.
Status quo BHU, specific performance. My lord, in my humble reading of the petition, I could not find out any prejudice to the parties. If a status quo as to the suit land is maintained in the suit is carried to the judgment. Nobody can do any harm to the suit property. It will be preserved.
Lordship, before lordship.
And suppression of material facts, my lord, rules order 39.
Lordship, kindly allow me to place my case. Lordship, before going on to the facts, the subject matter of this suit is a 22 bighas of land. And the valuation of the suit property is almost 1.5 crore, lordship.
Sir, we have to hear the appeal.
Lordship.
We have to hear the appeal. 17th of August, the status quo was passed.
Lordship.
Almost 3 months. Almost 3 months ago. You file informal paper books, let the appeal be heard out. We are not going to vacate that status quo just like that.
Lordship.
So do that. It is difficult for us to hear out the appeal because we don't have much time in hand. Esho, this appeal is directed against an interim order.
Contested.
Interim order?
Application under order 1 and 2 was disputed.
Yes, but still it's an introductory order. Interim order, not ad interim. It's an interim order. Dated August 17, 2024. Passed by the learned civil judge bracket senior division bracket closed Alipur Duar in OC suit 05 of 2021, comma, directing the appellant oblique defendant
Lordship.
to maintain status quo in respect of the suit property. Stop. The order was passed on contest. Stop. The defendant is paragraph. The defendant is aggrieved and is before us by way of this appeal. Stop. Paragraph. The appeal has to be heard. Stop. Let the appellant file requisite number of informal paper books, incorporating therein LCR need not be called for. All incorporating therein all relevant papers. Stop. All formalities are dispensed with. Stop. Since the respondent is represented, comma, notice of appeal is deemed to have been waived. Stop. Paragraph. The appellant will be at liberty to mention the matter before the then available circuit bench once paper books are prepared.
Yes.
Paragraph, the can is disposed of.
Get to it.
Five. 36.
36, I am for the respondent numbers 1 and 9.
1 and 9.
Yes.
What about 2 to 8?
Lordship, there are few respondents who could not serve. Lordship, on earlier occasion, there was a direction upon me to serve on the lower court advocate.
But it is later found that actually proceedings was it was proceeding ex parte against them.
No,
So there is no advocate.
Somehow you have to serve without
We
serving.
have
something.
attempted, but they are not. They are. I think they are avoiding actually. At the same address is mentioned in the plane, but they are.
How many
not-
times you have tried? You have tried once.
Twice, Lordship.
Try a third time, otherwise you have to go for substituted service. You have to serve. We can't proceed ex parte, just like that.
Lordship, item delivered for almost. Except different number 10, everybody has been served. Lordship. This is affidavit of service.
Right, but then 10 need not be heard, need not be served.
Lordship, they were pro forma respondent actually. Before the.
Substitute to publish করতে হবে। সে করবে কি পয়সা লাগবে তো আমি। Ask your client if you want to effect.
CBC also provides for email service as well.
Now email service.
Email ID has to be.
They don't know the email ID. Do whatever you like, but you have to complete service.
Lost.
The defendant number 10.
Lost. Respondent number 10.
Respondent number 10. The learned advocate for the appellant says that the respondent number 10 is yet to be served. Stop. Attempted service on him has failed. Stop. Paragraph. Let appropriate steps be taken. What else can we say? Appropriate steps be taken for effecting service on the respondent number 10. Whether personally or through email. Stop. Next circuit. Paragraph as requested, let this matter stand over till next circuit. Effective.
38.
In 38, I am for the appellant.
Nobody is there for the respondent.
39.
Pass over.
There was a defect in the appeal.
38.
Decree was not enclosed, subsequently it is filed.
Fine, there is no defect is reflected in the list.
39.
I am appealing for the appellant in 39. This is appealing for the first time.
Service effected.
No.
This matter has been listed for the first time. Stop. Let service of the memorandum of appeal and application for appropriate order.
No, stay.
Stay.
First stay.
Copy of memorandum of appeal and stay applications be served on the respondents and affidavit of service.
Injunction application.
Huh?
Application for injunction.
Copies of the memorandum of appeal and injunction application be served on the respondents and affidavit of service be filed in court on the next date. Paragraph, list this matter once again before the next available circuit bench.
Get.
40. 41.
41 I'm for the appellant. Admission.
42.
41. 41, is there any caveat?
No, there is no caveat.
42 চলছে
41.
41.
Affirmation.
Affirmation.
Hmm?
But I formulated three substantial question of law, madam.
Nature of the suit.
A preemption proceeding was initiated, madam.
Section 8.
Yes, the mandatory provision under section 9 has not been followed, madam. The refund with 10%. Sought for a decree that the decree passed in preemption case number 4 of 2000.
You are the purchaser. You are the purchaser.
Yes. Is in contravention of the provision of section 9.
Your real ground is round 2.
But if you also kindly comes to page 3 and 4, madam.
Just tell
Round
us.
9, 10 and 11. These are the substantial question of law.
Very well. Hey. Issue? This, no delay.
No.
This second appeal will be heard on the following substantial questions of law. করে এখান থেকে ground 9, 10, 11. Question form দিয়ে দেবে। ঠিক আছে? Paragraph, let the lower court records be called for. তারপরে কি? Is there a question of stay?
There is no question.
No question of stay. No. So, after the records arrive, let the requisite number of paper books be filed. Stop. Paragraph. Liberty to mention once the appeal is ready for hearing. So can is disposed of. Can't disposed of. Can to 41. Can nahi.
No, there is no can. Only the memo has been filed.
Admission.
কত নম্বর এটা? 41. Oh, আচ্ছা আচ্ছা, sorry.
Just admission.
Grateful.
42.
42, it's a order of affirmance, second appeal, there's a defect lordship, let you, kindly give me a leave to correct the defects
And next circuit.
I'm not ready.
Leave is granted to the learned advocate on record for the appellant to remove the defect as noted by the stamp reporter. Paragraph. As requested, let this matter be listed before the next available circuit bench.
Lordship, paying cost for password.
44. 45.
44. Passover.
45. 46.
Lordship, paying cost for password.
47.
7 I'm paying for not.
48.
For the appellant, it is also an order of affirmance, lordship.
Defect.
Stated that the box title is not according to the decree of the trial court. But my lord, I have changed it, box title is according to the decree of the appellate court, my lord. So what to do, my lord? The decree of trial court and the decree of appellate court is not matching. The cost title.
What do we do? Tell us. You take appropriate steps. What do we do?
Done the cost title according to the decree of the appellate court. But stamp reporter's report is cost title is not according to the.
So both are different. The trial court.
One name missing in the appellate court's decree.
So that can be rectified by the appellate court.
Yes, go there.
So that necessary steps. To take necessary steps.
Yes.
Learned advocate for the appellant says that there is a discrepancy between the cause title of the pleadings filed before the first appellate court and
The names which are written in the decree of the first appellate court is different from the decree of the trial court.
Discrepancy between the names of the parties appearing in the decree of the first appellate court and the names of the parties appearing in the decree of the trial court. Stop. The appellant has followed the trial court's decree in appellate courts. The appellate court's decree decree insofar as the names of the parties are concerned. However, this is the defect in the matter. Paragraph. Let appropriate steps be taken by the appellant for removing the defect. As requested, let this matter be listed again before the next circuit. Next available.
Here and now, my lord.
Do it if you can do it.
The preamble, my lord, I am doing that.
Do it next.
is a judgmental reversal, my lord. Plaintiff has filed a suit for eviction of a trespasser, my lord. When he was minor, my lord, so property was transferred by the.
Yeah, for the appellant.
I for the appellant, there is no caveat, my lord. Therefore, this is a judgment.
Question of law, where is
My
the
lord,
question?
your lordship can see the ground number 5.
Thou.
Your lordship can see whether, my lord, after attaining majority, the minor has to file a suit, Article 40, 60 or Article 64. My lord, your lordship can see, my lord, this particular point is under consideration by the division bench of this honorable court, my lord. May I hand over this particular?
Are we deciding the appeal today, sir?
No.
Then,
My lord, your lordship can see, my lord, the ground number 5.
that will be sufficient, ground number 5?
5 and 7, my lord.
5 and 7. Okay, sure. This second appeal will be heard on the following substantial questions of law. 5 and 7 দেবে গ্রাউন্ডটা অপূর্ব। 5 and ground 5 and 7 question form দেবে। Paragraph, let the lower court records be called for. You had obtained a decree before the trial court.
Trial court, my lord.
That has been, so there is no question of stay.
No, nothing.
Trial will be called for. So once the records arrive, comma, the appellant shall pay. ওই যে second appeal যে order হয়েছিল।
We shall put in the requisition, my lord.
Same.
100%.
Okay. 50 minute second appeal minute for admission. Let the prices.
Yes.
But I just take the facts in a nutshell, Millard. It's for admission, Millard would just consider whether.
What is the can?
The can, Millard, is the stay application. Stay.
Yes. What is the nature of the suit?
The nature of the suit, Millard, is for declaration. Millard, the plaintiff, Millard, claims herself to be the wife of a deceased tea garden worker. Now, Millard, after the death of the worker, his job was granted to the wife of his brother. The plaintiff, being the wife, relinquished her right to the job. She married someone else. She was residing outside the garden.
Plaintiff is the appellant.
Plaintiff is the appellant. Plaintiff is the respondent, Millard. The appellant, Millard, is the person, the lady who was doing the job. The wife of the brother of the deceased. Now, Millard, this plaintiff, the respondent Herin Millard, has subsequently, after lapse of Millard several years, came back and claimed the job, which was rejected by the management. Thereafter, Millard, she filed the suit. The learned lower court, trial court, as well as the first appellate court affirmed her right to the job, she being the wife. Now, Millard, the only substantial question, Millard, there are two substantial questions, Millard, which according to Millard, my limited understanding, Millard, I can frame. Number one, Millard, the tea garden jobs are, Millard, essentially in the nature of, Millard, it is called bodli jobs, which are, Millard, a customary in nature, Millard, where the purpose is that when a person dies while in job, irrespective of his age, the job is essentially given to a family member who resides within the garden so that the job remains with the family. The principles of compassionate appointment, where Millard, only the legal heirs are
Tell us which grounds, tell us, Mr.
Millard, ground has not been, Millard, framed in so many, Millard, in clear terms, but Millard would find this was argued. Millard, if Millard kindly takes, Millard, the
No, you have to take the ground, then amend your memo. At the ground.
Millard, the second question is, Millard, without examining one of the key witnesses, whether the job was waived by the wife, that question was not considered. That is, Millard, there in the ground number 7.
The other one, you add that ground, otherwise how will he allow you to urge it?
We will amend it. Milord. That 7 and 8, the second question we have framed.
Amend it today, come back tomorrow then.
Right, we will do it. Milord. Milord,
Leave
kindly
is
grant us that.
granted to the, leave is granted to learned, no, leave is granted to the appellant to amend the memorandum of appeal by incorporating additional grounds.
Yes.
Paragraph lists the matter once again tomorrow. Tomorrow date the other.
You want? 51, 52, 53, 52.
52.
I'm for the state, my lord.
The act is.
52. There's no private respondent, only official respondent.
My lord, in this matter, state was directed by the coordinate bench, honorable coordinate bench to file affidavit in opposition.
Yes.
Now the matter,
You want extension of time?
yes, my lord, because the issue relates to
Milord.
one letter of 2013, my lord, and the department is still searching with to ensure that letter. If
Matter is pending 2022, Milord. My peer only before the tribunal, my peer was only before the tribunal to consider my representation.
that is
Well,
only
that-
the issue, my lord, whether that representation has been filed before the superannuation or after the superannuation.
So let us
And
see
that-
that.
No, how does that matter? What is your problem if it
Yes.
is considered only?
Take a
But-
decision.
Take a decision.
My lord,
Yes.
since
Reject it.
Justice Basak has asked us to ascertain that later, my lord, which
So let
was-
let us see the order.
Dao.
Yes. Can I see the order? Last page, Milord. Of the report.
Which order?
The order dated 13 January 2015. Last page of the application, my application.
No,
The hearing order.
13 January.
Tribunal order দেখতে দিয়েছে। 35
13 January.
The last day আছে নাকি?
হ্যাঁ, একদম
13 January
2015.
2015. ও 2015 সালে না। So your application was dismissed on the ground of limitation.
limitation. But Milord, I made an application before that, Milord, several. In 98, I made an application. In 2000, I made an application. 2006, I made an application, but that has not been considered by the tribunal.
Sir, we can cut it short.
kindly come to order dated 16th of November 2023. Passed by this honorable coordinate bench.
Yes. Where? Which page?
My lord, the first page only. No, the order passed by the coordinate bench.
Yes, yes. Wait.
Not in the writ petition, not in the application, my lord.
Yes, but where?
Sir, we have seen it. We have seen it. It was an interim direction. We can dispose of this matter. Only consider and
Yes.
take a decision. We are not asking you to allow his representation.
But
That will cut matter শেষ করে দাও। হ্যাঁ, এসো।
we are stuck with this order, my lord.
Under challenge in this writ petition is an order dated January 13, 2015, passed by the West Bengal Administrative Tribunal in case number OA 293 of 2014, filed by the present petitioner. Stop. Paragraph. The petitioner worked as Onchol Development, এই শোনো এখানে সব পেয়ে যাবে, মার্ক করে দিচ্ছি ট্রাইব্যুনাল অর্ডারটা। Onchol Development Worker oblique Onchol plan worker
Plan.
in Holdibari development block of Coach Bihar district. He retired in the year 2013 on superannuation. Stop. He started receiving pension on the basis of last pay drawn by him. Paragraph. He says that he filed a representation before the competent authority seeking benefit of memo number 6303-F dated 29/05/1984, issued by the state government. Stop. That pertain to a promotional scheme. Stop. He claims to have made several representations and demands for justice, but there was no response from the authorities. Stop. He approached the tribunal praying for a direction on the respondents to allow him promotional benefits in terms of the aforesaid memo and fix his pay and terminal benefit accordingly. Paragraph. The tribunal dismissed the application of the present writ petitioner solely on the ground that he had not raised his claim for 30 years after issuance of the 1984 memo. Stop. The tribunal did not address the merits of the case at all. Stop. Being aggrieved, the present writ petitioner, the writ petitioner is before us. Being aggrieved, the writ petitioner is before us. Paragraph. We have heard learned counsel for the parties. Stop. It appears that the petitioner made a representation on January 31, 2013, immediately prior to his retirement. Stop. Should he make a fresh representation, or where do you find this out?
My lord, the department is searching this letter, my lord.
It will be easier for you if he again files that representation before you.
My lord.
It will be easier for you.
Last
Stop.
week.
Learned advocate for the respondents says that the department is still looking for the
Page 46. My application.
the said representation. Stop. Said representation for filing affidavit in terms of the direction of a coordinate bench passed on November 16, 2023, on this writ petition. Paragraph. We are of the view that the matter can be cut short. Stop. Let the petitioner file a fresh copy of his aforesaid representation dated June 30, 2013, January 30, 2013, before the competent authority in the department within a week from date. Stop. If that is done by the petitioner, the competent authority shall dispose of such representation, comma, in accordance with law and the applicable rules and regulations, comma, within a period of 6 weeks from the date of receipt of the representation, comma, after granting an opportunity of hearing to the petitioner or his authorized representative. Stop. The decision taken by the competent authority shall be communicated to the petitioner within a week from the date of the decision. Paragraph, we clarify that we are not binding the hands of the authority in any particular manner. Stop. The competent authority shall take an independent decision in accordance with law. Paragraph disposed of.
That later dated is, my lord, January 31st.
ও January 31, 2013.
Fine.
30 বলেছিল, ঠিক আছে?
বিপ্লব। এই যে।
এই একটা ক্যান আছে দেখছি, ক্যানটাও ডিসপোজ অফ। What is the can?
Can I file the application for condonation? There is some condonation.
That was allowed.
Condonation. Condonation. Like the order dated.
Disposed of, very disposed of.
Disposed.
Everything disposed of.
53, 54, no, 54 is what?
Before, my lord, in this matter, my lord, I am appearing for the applicant being CA number 1 of 2024. This is my application for addition of party.
Very well, that will be hard letter. But in this matter.
No, Mr.
Because,
Doctor,
my lord,
all very well, but you have exactly 15 minutes.
My lord.
Will it be of any?
But I have no objection, my lord, no problem. My lord, only request I can make your lordship, in that case, kindly take up the matter tomorrow, my lord, and the first matter. Give me that preference.
As your lordship pleases, my lord. As your lordship pleases.
Please, that preference kindly, my lord, I am waiting. Lord, it will not take much time. It will not take, my lord, much, not more than 20 minutes time.
You have to hear all the learned counsels, okay? It will take time.
No, not at all, my lord. That is what I assure you.
Any scope of any interim order?
But it is not, please, my lord, if I am allowed to speak.
My lord,
Because, my lord, I will take at least 15 minutes.
I know that, you need not. Because after my submission, I don't
the
think, my
fraud
lord, your
have been
lordship would
practiced
be
in
called
such a
them.
manner.
So, my
The
lord,
fraud has
kindly
been
give
practiced
me.
in such a manner.
My lord, everybody's intention, my lord, is to, my lord, get this matter adjourned 15 minutes, 30 minutes time will say. But that is the strategy.
Don't make such presumptions.
That is a strategy.
May not be. That is your understanding.
Come back at 4 p.m.
My lord, today,
Today.
Yes.
today.
4 p.m. এইটা যেটা এরা
Lordship, tomorrow morning, my lord, if your lordship will kindly accommodate me tomorrow morning.
Mr. Roy, very difficult. We can't accommodate everybody. We
No,
are
my
under
lord,
tremendous pressure.
I know, my lord. I can
No,
visit
no.
your lordship subject to my
Oh,
lord's.
sorry.
So, my lord, will come back tomorrow.
Lordship, in this matter, I beg to appeal for this state led by learned additional advocate general, Lordship.
56.
Lordship, this matter is running in the list since last 1 week. Petitioner did not appear, Lordship, in this matter.
Okay, to
Really? Next circuit করে দাও তো 55 টা। Hey, 55 habeas corpus. though.
Yes, Lordship.
It is running from Monday.
Nobody has appeared.
Nobody has appeared.
Has it
because-
been called on
because this
before?
Cannot be heaviest corpus. At best, police in action. That I have asked before the honorable coordinate bench, the last occasion.
Uh,
Report has been filed, progress report and everything is.
on several occasions, this matter was called on, stopped, nobody appeared for the petitioner. But then, Mr. Chaudhary, this is a habeas corpus matter. We don't want to pass any adverse order in their,
Consecutive time,
in
since
their-
Monday. I leave it to your lordship, I do not want to, in their absence, I do not want to praise them.
yes.
I leave it to your lordship.
We will merely say not today, or this day after tomorrow. Thursday, Ashok, দেখা যাবে। Now, let automatically it will be next circuit.
No,
Thursday?
can it be dismissed, sir?
No. No, we are not dismissing in that.
My
manner.
brother will not permit me to dismiss any matter.
Then you are always acting the appellant.
Thursday রেখে দাও।
Anyway, early, if it is not taken up, you take your chance in the next circuit.
Not that.
Grateful.
57.
Appellant,
Appellant.
on the prayer made on behalf of the appellant, let this matter stand adjourned stand over till the next circuit. Stand over till the next circuit.
58. 59.
Here, my lord, I am the appellant, my lord.
59, it is hearing matters.
No
Anyway,
sooner said he took the chance.
your other side is, Mr. Mujumdar, your other side.
59, my lord, I think,
Paper boy already read.
Das, Mr. Das is appearing, my lord. My lord, here I will take 5 minutes, my lord. Because of this, I have sought for a divorce, my lord, which has been turned down by the learned judge, my lord. Challenging that, I have preferred an appeal, my lord. There is since 2011, we are separated. Now it is 2024. 498 cases have been filed in 2012. It has not been tried.
Your ground was mental cruelty.
My ground was mental cruelty and as well as the desertion, my lord. Otherwise, my lord, it became because, my lord, when
You
there
are
is no
appealing.
tie.
I'll appear later, fix it next.
You are for the
Next
respondent wife.
Wife for the wife.
Mediation, have you
My
tried?
lord,
making-
reconciliation was made an effort. She did not participate, my lord. It is reflected in the order sheet. In the section 24, my lord, she has a sufficient income. Court observed that she has not come in a clean hand. Everything, my lord. So, my lord, the question remains, my lord. Now both are aging, my lord. When this matrimonial tied institution there is no existence of the institution, my lord. Unnecessary, my lord, since this is the reason, my lord, I am.
No, are you willing to take your wife back?
Yes,
My lord,
that is my question.
That is, are you willing? So matter can be best resolved.
my lord, the question, even my willingness.
Yes,
My willingness, she said,
yes.
I had to stay separately away from my parents. That amounts to a cruelty. That is reflected. Even I cannot
Even
leave
you
my.
see, 10 years have passed. You make another chance. Make another effort. 10 years have passed. You see, 2011, your suit was instituted.
He doesn't know.
2011. Thereafter, 12 years have passed. Take another chance for reconciliation.
For reconciliation.
Yes, yes, yes.
Lord, I have no problem, Milan. I have a full love and affection.
So you
but
take
only
chance.
Malad, kindly.
I'm ready to accept anything.
How was reconciliation
There
attempted?
is no ground for divorce. In fact, there is no ground.
Very
at
well,
all.
very well. Now try to settle the dispute.
Today, is there a possibility of the parties going before a mediator?
Milord, even Milord, that will be a futile exercise. With respect, Milord, I am saying why, Milord? Always since my marriage, Milord, the persistent efforts were made. She said, I want to stay separately with you. I cannot leave my parents. They are the aged people.
How
So,
does
man,
he
this
make
is-
submission, all these things?
That
Please
I
put
will.
down.
That I.
Now,
He's
now your learned friend will convince his client
In
to
fact-
reconsider that
in fact,
matter.
the matter. The fact
Milord,
is,
again, Milord, what will happen, Milord? It will pass another year.
See, we are not in a position to dispose your appeal. Okay, it will take time. So
Milord, I
better,
understand, Milord.
better let it be go. Let it go for mediation. If it fails, you come again to court.
Milord,
let it go on merit. There is no ground at all.
Very
I'm,
good. Next circuit.
Milord,
I'm ready to go.
Milord,
I'm ready to go if he accepts. He wants to play a second innings.
Ready to go where?
to my husband. If he accepts, I'm ready to go with my husband. Still
Then there are another 498A.
He is ready to accept you, provided you don't insist that he has to stay away from his parents.
But
No,
that's
so he lives alone with 3-story building. His parents are dead.
What?
His parents
my
are
family
dead.
by this time.
He's telling he's not
By this time.
well aware of this fact.
Since
His
last 13
parents
years,
are well are not here.
Better go before the next circuit. Mr. Chaudhary.
but at the next circuit, I understand.
It is a 3-story building.
Then also,
Yes.
my, what is the,
Javed.
but the difficulties I have predicament of this, honorable court, I understand. Because burden of the flooded with the other matter,
Yes.
criminal matter, this appeal will take some time, that I understand.
Yes.
But in the next circuit, a similar situation will arise, my lord. Someone to take the responsibility,
Lord,
otherwise
let
when
the
will
matter
someone
be hard on Mary.
just
Or
again,
let the matter be hard on Mary.
but this
I
is
don't
not
have
the
any objection to
decorum, my
obtain
lord.
the ground. Either the matter
Plus
be hard on
maintain
Mary.
the high court
or
order.
Why do you get so excited? Why? All the time? We find you to be agitated, excited, bad for your health.
Because he's not telling the correct submissions. So
You can
he's not
correct
making-
him once he finishes. You can tell us
Okay.
he was
Let
wrong.
him
1, 2,
finish.
3,
Let
4,
him
5, 6.
go on.
Go before the next circuit, Mr. Chaudhary.
My lord, can I take a chance tomorrow? If I can convince your lordship, okay, I will take sharply 7 minutes. Within a 7 minutes, if I
You
cannot,
see, these matters are not so easy.
my lord, 7 minutes,
Matrimonial matters.
I am confident, my lord. Within a 7 minutes, I will be able to convince your lordships.
Yes.
If not, kindly
Then
fix the matter next circuit.
We will have to hear him also.
7 and 10 minutes, 3 minutes more he will take.
No.
Better you
Because
convince-
I say all the.
You see, let the matter go to the next circuit.
Yes,
In the meantime, both of you convince yourself so that you can advise your client properly.
This appeal is directed against the judgment and decree of
Judgment and decree, my lord, of the additional district judge, second court, Siliguri.
Pecho, whereby the appellant's suit seeking divorce from the respondent, was dismissed. Stop. Paragraph. We have heard learned counsel for the parties for some time. Stop. We are of the view that there is an element of settlement in this matter. Stop. Time will not permit us to hear out this appeal in this circuit. Stop. Let this matter stand over till the next circuit. Stop. Paragraph. In the meantime, we request the parties to sit across the table and try to sort out their differences so that they can resume their life together. That's all.
Lord, I understand these efforts always we made, lobsters made, but ultimately, my lord, after a long, prolonged period of a decade, more than a decade, my lord.
But there are cases where matters are settled, matters are reconciled. Both sides,
I
matters
understand
dissolved as well as
parties
matters
must be
settled.
very conscious about their future aspects. That is the only, it is a person to person is various.
Yes.
So here, my lord, the checkered history, it is not possible, even feasible even.
Then it has to be heard out on merits.
But all right, lordship, I do not want to, I understand your lordship difficulties, so many orders, so many judgments you have.
Yes.
All right. Yes, I'm grateful, ma'am.
Lordship, item number 55 just passed now, Lordship. I pray for
This is not a time for mentioning, sir. Daku. 60? On the prayer made on behalf of the appellant. Huh? Let this matter stand over till the next circuit.
61, my lord, I am for the respondent.
Cholo.
63.
63, my lord, we stand to respond.
64.
Well, 64, there is a direction to.
Yes?
Mr. Rudra will appear.
in this matter 64 and 65.
He's for the appellant. Can't understand the thing of what he's saying.
Well, there is a direction to file a report. The college authority, that matter, college authority. I serve the college authority, file the report to the learned state, my lord. So, and also there is a direction to advance copy to serve the advance copy to the petitioner, appellant, my lord. So my lord, kindly
You are appealing.
Hero Bormon.
Nobody is here excepting you.
64, 65.
66.
64
Contact number 1.
Chalo,
66, I am for the scholarship.
I'm praying for not to.
not today.
Lordship,
Chalo,
and
chalo,
this
chalo, chalo,
matter,
chalo, chalo, chalo.
Lordship, then it is, let the matter be fixed on next circuit.
Next, 67.
Lordship, I pray for next circuit.
You are for the appellant.
Yes, your lordship.
On the prayer, same order, huh? Stand over till next circuit.
68.
We are praying from not today.
69.
My lordship, item 69, I'm praying for next circuit.
Next circuit, same order korbe. Prayer made on behalf of the appellant.
Gratefully, lordship.
Item number 70.
My lord, in this matter, I am for the appellant, my lord. Since time is short, my lord, can it be
Next circuit.
next circuit? My lord. I tried my luck, my lord, for 2 days, but I can understand.
Item number 71.
On the prayer made on behalf of the appellants.
I'm for the appellant, my lord. 70 items.
Item 71 was time for the appeal. There was
71
direction for paper book, because the paper book has been prepared.
has been prepared. File it in the department. এখানে কি করে কোথায় ফাইল করে? ডিপার্টমেন্টে।
I will help to here, Lord.
What?
To be tagged with the file, Lord.
ও ফাইল আছে এখানে? Oh, there's a procedure. File it in the department.
These are informal paper books.
এখানে let it the informal paper books filed in court today be kept with the records. Stop, let copies be made available to learned advocates for the respondents. Paragraph, list this matter before the next available circuit bench.
I'm obliged. 72. 72 was time for the respondent. 73. 73 stacked with 72.
Tagged.
74.
Well, 74, I'm for the appellants, but I'll need a little more time for filing the paper books that have already been.
Paper book, we haven't submitted.
On the prayer made on behalf of the appellants, time to file paper books is extended by,
Well, please kindly place it in the next circuit. For a week,
is extended by a week from date.
Lordship.
Date ta diye diyo bracket stop, paragraph. As requested, let this matter be listed again before the next available circuit bench.
Grateful. But same.
Same order, 75.
Same, man.
Same order,
Same. Man.
same order. Great.
Grateful.
Hello, the indentures of your lordship. Item number 22.
Yes,
Match 97 of 2024.
yes,
I had spent a sleepless night
yes.
last night, and this morning at 8 o'clock I could complete typing it my room. and-
File it, file it, file it, file it. Give it, give a copy to, give a copy to Mr. Chaudhary.
So, Matt
Take a copy.
97, item number 20.
হ্যাঁ, তো নিয়ে নাও উনি যেটা দিচ্ছেন।
18 notes of argument,
Yeah.
I'm filing, ready to be on.
Yes, yes, you're taking it. শোনো, yes, yes, take copies. ওই যে করেছে 22টা যে করেছে অর্ডারটা, একটা অ্যাড করে দেবে ওখানে, ওই লাস্ট লাইনটার আগে অ্যাড করবে, written notes filed on behalf of the private respondent be kept with the records. তারপরে বোধহয় লিস্ট করতে বলেছি ফর অর্ডার্স টুমরো। এইটা খালি ওই লিস্টিং এর আগে, লিস্টিং ডিরেকশনটার আগে দিয়ে দেবে। ইয়েস,
11 was passed over.
we'll see tomorrow, yes. From 12 o'clock, we said we'll take up bail matters. Let us see, we don't know.
That's why the CD came there. So the evidence in the lower court would not be.
How long you are in custody?
One. I'm in custodiable 380 days, my lord. There is no eyewitness, my lord. All other
No,
seven.
there the weapon was recovered on the statement of this accused petitioner, and the body was also recovered from on the statement of this petitioner. The other accused persons who were named in 164 are granted bail.
My lord, there is no eyewitness, my lord.
Forget about that. Why did your counsel take adjournment on the last two occasions?
One thing, that, my lord, sometimes it happens, my lord, it is at about 4 PM or 4:30, then.
No,
after-
you're speculating, Mr. Poddar. You don't know. You are not the trial court lawyer, so you have no idea. Again, you say maybe.
Total 36 witnesses.
You were supposed to tell us how many witnesses the prosecution intends to.
This is key, after going to the first 10-12 witnesses, the prosecution will be each at the lower court.
So therefore, we proceed on the basis all 30.
For the time being, time may be framed, ma'am.
We cannot, Mr. Chakraborty. we
We'll
told you
request to
repeatedly.
expedite.
Esho.
It says 20 witnesses.
He has no idea. His demeanor doesn't inspire any confidence. The petitioner says that he is in custody for 379 days.
Milord, one indulgence, Milord.
Stop.
Milord, on behalf of de facto complainant, his son was brutally killed, Milord. And there is leading statement, Milord, and CPR connection is also there, Milord.
If it can be established.
No, we'll record your objection. Okay.
If it can be established.
And condition will be there.
They'll be either hanged or life imprisonment. We are not acquitting them.
Milord, it will seriously impact the belief of the de facto complainant upon the sisters, Milord. And there are threats, Milord, upon the de facto.
No, definitely we will impose stringent condition.
379 days. Stop. The examination of the first prosecution witness has just begun. Stop. There are 30 charge sheet named witnesses. Stop. There is no eyewitness to the alleged incident. Stop. The entire case is based on circumstantial evidence. Stop. Primarily on the ground of delay in progress of trial, the petitioner prays for bail. Renews his prayer for, renews. Oh, not praised. Prays for bail. Stop. Paragraph opposing the prayer, learned advocates for the state and the de facto complainant submit that it may be that the evidence is circumstantial, but the prosecution has been able to complete the chain of circumstances. Stop. The offending weapon and the dead body were recovered on the basis of statements made by the petitioner. Stop. All efforts will be made to expedite the trial. Stop. Paragraph. The prosecution may have an iron cast case against the petitioner to secure his conviction. Stop. Indeed, if that be so, the trial should be proceeded with as much expedition as possible, so that the petitioner can be punished if he is found to be guilty. Stop. However, comma, the pace at which the trial has progressed so far, comma, indicates that there is very little chance of an early conclusion of the trial. Stop. Paragraph purely on the touchstone of Article 21 of the Constitution, comma, keeping in mind that an under trial person's fundamental right to personal liberty and speedy trial is paramount, comma, we are constrained, and noting that some of the other accused persons are on bail, comma, we are constrained to allow the petitioner's prayer for bail. Accordingly, any condition you want to impose, Mr.
My lord,
Chakraborty?
only one thing that they should not take any adjournment.
Yes,
area enter ওটাতে থাকবে, not to enter the area.
সেটা তো থাকবে, not to enter what? হ্যাঁ? নিয়ে নেওয়ার কাছ থেকে করতে পারো।
Except for meeting the except meeting those.
Except for the purpose of meeting these, তো জানো তো এগুলো ওভাবে দেখাচ্ছ না, মনে হচ্ছে প্রথমবার শুনছো।
I'm not to meet the persons acquainted with the facts of the case.
একটা জায়গায় ঢুকিয়ে দেবে। It is in the interest of everybody that a criminal trial concludes on an early date. Stop. We direct the learned trial court not to grant unnecessary adjournments to either of the parties.
Because they go and they have to come back, so grateful.
I just received the case. Can you give it back to PM?
2 p.m. Come back tomorrow. Not today.
81.
Anyway, you tell us, you tell us.
Lord, I pay for the petition, my lord.
Foreigners Act. What documents have you produced? Verify.
My lord, we have already the last occasion, verification has been done.
Oh.
The PAN card is okay. Now they have come on parity, my lord. So regarding parity, already one accused, same accused has been granted.
Oh.
My lord, your lordship.
Similarly circumstanced.
Yes, my lord, your lordship has already, my lord. Lord, I pay for the petition as similarly placed circumstance person, my lord, has been granted bail. My lord, I have annexed the order, my lord, also.
Where is the order?
last part
Page 20, my lord.
14
Acha.
14.5, my lord, annexed page 6 at page 20.
এই জন্য আমার এই virtual না একদম পছন্দ হয়। Where is your report? Have you verified? Oh, you have not filed. That's why we can't.
Just now I have given.
দেখি রিপোর্টটা দাও। What has been found to be authentic? Epic card, PAN card.
ওতে ওই ভোটার কার্ডটা জেনুইন বলে বেলটা দিই। Although it is out there, there is out there.
It's written in ward number 29 of Kolkata. Is it?
Report issue. Report. Oh, report filed by the state in terms of our order dated November 8, 2024, we kept with the records. Stop. From the report, we find that the PAN card of the petitioner has been found to be a genuine document. Stop. Paragraph. In that view of the matter, and also noting that a co-accused person, similarly circumstanced as this petitioner, was granted bail by a coordinate bench on May 14, 2024 in CRM DB 224 of 2024, we are inclined to allow the prayer of the petitioner.
Deeply obliged.
Same condition, এই যে page 20 তে যেগুলো আছে, same condition.
Particularly paragraph 5, Lord. Obliged, Lord, deeply obliged.
Lordship, I am for the petitioner, Lordship. Involving section 300 to 34, 120B, 174A, Lordship. Principal accused granted bail. Another two accused person also granted bail from this coordinate bench. Page 20 is the principal accused order, Lordship. Page 17 and page 15 is the co-accused.
How long you are in custody?
Lordship, 149 days, Lordship. Voluntary surrender before the court below, Lordship. And
Yes, sir.
Yes, which page?
It's the case where a police personnel while on leave
Yes.
brutally stabbed to death because of a dispute
not by
regarding
me,
a bond.
Lordship, by.
Yes, yes, yes.
Now what he is submitting, there are a lot of eyewitnesses, both 164 and 161 has been recorded. Video footage is there of the incident.
What is his complicity, this person?
He was along with the person who has stabbed.
He
I am the brother of the principal.
Okay, which page?
He may have been present, sir, but the prime assailant was this Shukmonto.
Yes, Lordship.
Shukmonto was behind the bar for 686 days. Thereafter, WPA proceedings exhausted and he had to surrender before the court and now he has come out.
No, where is the 164 statement page?
Lordship, I am the
164 of friend eyewitness page 64 maternal
64.
yes maternal uncle of the deceased page 88.
64.
Lordship, all the allegation against the Shukmonto Burman also FIR stated that the Shukmonto.
Allegation against Shukumonto is he stabbed, but there are other
No, there is his participation, but the overt act is by the principal.
but
He is involved.
Yes, but he was behind the bar for 686 days. That was
Now charge sheet is submitted.
Yes,
Charge
charge sheet
sheet
submitted, trial as commenced.
Charge frame on 4th March 2022. Only one witness has been examined partly.
Because of the fact that WPA has to be
No, how long he was absconding, this petitioner?
Lordship,
from
after
year 2021. Thereafter,
Lordship, may I-
WPA was exhausted and the trial started. And he has nothing to-
We detest two counsel addressing together.
I was asked. I apologize.
How many witnesses to be examined?
14.
14.
My-
1-4.
Another thing. Today is fixed for evidence, 12-11.
Lordship, may I,
CD is here. The evidence
may I,
cannot be
Lordship,
conducted.
may I, Lordship, one thing, Lordship?
Yes.
Lordship, before filing charge sheet, the court below was issue warrant WA and thereafter WPA. We have challenged that order, WPA order before the.
Anyway, now you are in custody, you have surrendered.
Yes, Lordship, I have surrendered and Lordship.
Yes, all accused persons are before the court. At present, all accused.
No. Still there are 3 accused persons.
So
against
trial
the
is going,
WPA.
trial is going on.
Split trial has begun. From August, the CD is over here because of.
Issue.
Lordship, petitioner is the member of the Kuchbihar Bar Association, unfortunately.
File has been
Wait, my lord, 13 August, thereafter she kept with my office, my lord.
Anyway, we'll direct that to expedite the trial.
My lord, my lord.
Lordship,
My lord,
Unnecessary adjournment by the
that
trial.
is one of the tactics.
Lordship,
Problem is,
petitioner is
Mr.
the member of the Kuchbihar Bar Association.
Chakraborty,
Who transfer?
40 witnesses.
So he's a member of the Kuchbihar Bar
Yes,
Association,
Lordship.
the petitioner.
Yes, Lordship.
That is neither here nor
No,
there.
Lordship.
My lord, all the witness need not be taken care of. Eyewitnesses.
Why do you need him in custody? Tell us. Why? How will it help your trial? How will it help your trial?
Person, my lord,
Sorry?
they are influential person over there. He himself is stating they will tamper with the witness.
They are the police personnel. Lordship.
Chalo, issue. The petitioner says that the principal accused has been granted bail by order dated February 7, 2023, passed in CRM DB 56 of 2023, stop. Two other accused persons have also been enlarged on bail by orders dated November 26, 2021, passed in CRM 1036 of 2021, and dated May 5, 2022, passed in CRM DB 115 of 2022. Stop. He is in custody for 146 days. Stop. Examination of the first prosecution witness has just started. Stop. There are 40 charge sheet named witnesses. Stop. There is no possibility of an early conclusion of the trial. Stop. There is no such incriminating material against him as would justify his continued detention in judicial custody. Paragraph. Opposing the prayer for bail, comma, learned state advocate says that the petitioner was absconding for more than 2 years. Stop. Warrant of arrest was issued against him. Stop. Only thereafter he surrendered before the learned trial court. Stop. He is an influential person. Stop. He is a member of the Kuchbihar Bar Association. Stop. If enlarged on bail, comma, he is likely to influence prosecution witnesses. Stop. Paragraph, we have considered the rival contentions of the parties. Stop. It is not that the petitioner was arrested. Stop. He voluntarily surrendered before the learned trial court. Stop. He is also in custody for about 5 months. Stop. Regarding the apprehension of the state that he may tamper with evidence or influence witnesses, comma, the same can be taken care of by imposing appropriate conditions for bail. Stop. There is no possibility of an early conclusion of the trial, given that there are 40 charge sheet named witnesses.
14 or 40? 40.
Stop. We do not see why further custodial detention of the petitioner is necessary. Stop. Accordingly. Correct. Next.
45 years.
45, 40 ton or 45.
Warrant of arrest after he was declared a proclaimed offender.
আচ্ছা,
When he-
ওইখানে warrant of arrest was issued যেখানে বলেছো, and he was declared a proclaimed offender. He will not, with the usual, he will stay out of what? Where is the trial?
Yeah, Kuchbihar district.
Stay out of Kuchbihar excepting for attending trial. হ্যাঁ, যেখানে থাকবে তার লোকাল অ্যাড্রেস দেবে, লোকাল পুলিশকে once every fortnight গিয়ে পুলিশের কাছে রিপোর্ট করবে। আর এটা তুমি কি যে বলুন, will not contact anybody.
A person contact the persons acquainted with the facts of the case.
And for the defector.
Lordship, yesterday this matter was heard. And my lord directed me to supply the deposition copy to the state.
Yes.
I have already supplied deposition of.
How many witnesses have been examined?
Well, 13 witnesses.
12
witnesses
1-3.
have been examined.
1-3, my lord,
Have-
out of 26.
Lordship, 1-2.
And a schedule has been framed, my lord, from 9.
You have told us that. Tell us how far these witnesses have implicated this petitioner.
The de facto complainant, my lord, who is the husband of the, my lord, the deceased victim. My lord, his testimony precisely corroborates, my lord, the entire prosecution case. Having been, my lord, heard the incident, my lord, he rushed to the spot, my lord, and he, my lord, heard the incident from the mouth of her, the deceased victim, that is her wife. Before, my lord, he was taken to hospital.
Show us that portion of the deposition.
Lordship, please allow me to give me the reply afterwards.
This is your renewal.
In February, it was rejected. February 2020.
Then why should we?
Lordship, I'm coming. Lordship, I have a copy for my lords also. If my lord sees.
Yes.
1 minute only, Lordship. I have a copy for the Lordships also.
What?
For deposition, all deposition.
Yes.
Lordship. Then kindly, I have made a bullet note of the discrepancies in the. Lordship, may I?
Mr. Ganguly, discrepancies argue before the trial court.
Now, Lordship, my handball submission.
Right.
Lordship, the case is, only 3 points I'm going to raise. The case is that the de facto complaint was that he, after getting a telephone from his wife that he has been stabbed by me, he came and heard the same from his wife. Lordship, the case was registered on 27/6/2023. The accused was arrested on 26/6/2023. PW 2 and 3. Neighbors, they have categorically stated. Now, the recovery portion on 27 evening, I was already in custody in 26. How can the recovery be from me? Number 2, the Caesar witnesses have deposed that the article, that chain which was seized from my house, they were kept outside. The police entered the house, came out with the chain and told that this has been recovered. Now, Lordship, any intimation or any reflection of what I am stating now, what I have given in the order sheet may affect the trial. What I only say, Lordship, that is the reason I was not entering into the evidence. I know the case is bad, but if Lordship sees my the discrepancies, Lordship will find. 12, Lordship, and 500 days.
How many?
12 witnesses examined.
26 total witness, out of them
12 examined.
So this, there is the declaration from the victim
Lordship.
regarding who caused injury.
Victim deceased, Lordship.
Disease means victim.
So,
And any witnesses who have seen any assault?
Next deposition, PW 2.
No, any 161 that who has seen the assault. Any 160 or 161?
May I hand over the 164 statement, madam?
Yes. Who have seen this.
Provided you can show us that somebody has said, I witness or something.
No, nothing.
My lord, no eyewitness, my lord, the de facto complaint is the husband, madam, of the deceased.
No eyewitness thing. There is no eyewitness.
No, but only PW2, madam.
Yes.
Kindly have a look on the PW2 deposition.
Tell us what he has
Madam,
said.
he said that as per her testimony, he saw the, my lord, the accused person was standing, my lord, in front of the gate of the house, where the, my lord, Alice incident took place.
Any recovery from this accused person? Recovery?
My lord, the chain, my lord.
No, any weapon.
My lord,
Cause of death is burn,
yes, my lord.
cut injury.
Yes,
Yes,
my
sir. The
It was
demand was recovered 127, but the accused was arrested on 26.
It was recovered.
So my only contention, Lordship, 500 more days, 12 witnesses examined. Now 13 witnesses, another 500 days. So I just
You are in
wanted
custody for 500 days.
more than 500. So what I only pray, Lordship, at least interim bail, so that the main witnesses, they complain and they have been examined. No chance of tampering with the evidence.
Just a minute. Regarding 164, 7 except this declaration from this victim by the de facto complainant, any other person?
Yeshua. The petitioner renews his prayer for bail, which was rejected earlier on February 22, 2024. Stop. He says that now he is in custody for more than 500 days. Stop. Only 12 out of 27 charge sheet named witnesses, 26 charge sheet named witnesses have been examined. Stop. There is no possibility of an early conclusion of the trial. Stop. On the touchstone of Article 21 of the Constitution of India, the petitioner prays for bail. Paragraph. Learned advocate for the state vehemently opposes the prayer. Stop. He draws to our notice depositions of the 12 prosecution witnesses already examined. Stop. The PW1, being the husband of the deceased lady, squarely implicates this petitioner. Stop. Paragraph. However, we have always said that however strong the prosecution case may be, that would not justify incarceration of the under trial accused person for an indefinitely long period of time. Stop. The petitioner has already spent more than 500 days in judicial custody. Stop. There is very little likelihood of the trial concluding on an early date. Stop. Paragraph. Keeping in mind the fundamental right of a person to personal liberty and speedy trial, we are inclined to grant interim bail to the petitioner. Paragraph. This order of interim bail shall continue till December 20, 2024, or until further order, whichever is earlier. Stop. Paragraph. Place this matter before the next available circuit bench. Condition গুলো তো থাকবেই। Yes.
Lordship, now the problem is, may I hand over my copy? Alice's, the name is Montu De. In Coslis also, Lordship, it's been Montu De. But
yes.
he's praying bail on behalf of
84 to. Montu De.
Montu De. Now, Lordship, please turn the page. Chitro
Oh, the petition cause title is Chitro Singho.
Chitra Singh. The police could not find any Chitra Singh Lordship.
Not today.
85.
85 and 89 are the same.
85.
85 state,
85 and 89 one day ago.
not today.
89 also.
86.
Yes, tell us, tell us, tell us.
This case was initiated under section 302 lordship. So if I name access lordship, the circumstances and evidence lordship, it started submitted against the court. This person one of the base lordship, 35 days in custody, included copy of charge not made lordship.
What is there against Bappa?
Lord, he is the principal accused. My lord, the co-accused persons.
Eyewitness? No
No, my
eyewitness.
lord, no eyewitness. But my lord, he had hired two, my lord, persons to kill the person, deceased person. Now, my lord, during the last rejection order of the co-accused, my lord, there is a specific observation of this honorable court that this, my lord, may kindly see the.
Yes, where is that?
245 days only.
35 days in custody.
235 days.
Yes, when it was last rejected?
My lord, not his, but the co-accused persons.
No, there is no earlier rejection.
For him, this is the first time, but my lord, may kindly see the observation in paragraph 2.
Raja Rai.
Raja Rai is the person, my lord, who has been hired by him.
Principal accused Bappa Rai.
The professional person is hired killer.
Hired killer হচ্ছে রাজা রায়।
Only this petitioner.
Petitioner ওকে hire করেছিল উকিল।
Petitioner.
Copy or serve lordship, one of the accused is on bail lordship.
Okay, let us see the statements, 164 and the other. Yes.
My lord, their call detail records were also traced out, my lord. It has come to the light, my lord, during investigation that the persons who were hired by him, there were continuous calls between the persons, my
Yes,
lord, on the
page,
day of.
which page, 164?
My lord, no 164, my lord, 161 statements are
Yes.
there. My lord, even page 4 is the 161 statement of the complaint.
Oh.
Charge sheet was filed when?
Charge sheet submitted on 11th of June 2024.
And lordship, the last portion of the charge sheet,
And my lord,
lordship, the supplementary charge sheet will be filed after collecting the RFS and
Anyway, this person was named in the FIR.
no lordship.
my lord, 161 statement of the neighbor. My lord, may kindly see page 30.
161, okay.
Yes.
Page 4.
Page 38.
Page 38. Page 38. No, page 38 is the IO's report.
My lord, may also see page number 26. My lord, that is a handwritten note of the deceased person.
Handwritten note.
Yes.
Of deceased lordship. Now,
What is there in this handwritten note?
My lord, he has taken the name of this Neil Rai that he used to, my lord, disturb, he used to assault him.
And this has been recovered from, and there was
It's
certain.
very confusing. Raja Rai is also Neil, Bappa Rai is
Milord,
also
he has
Neil.
alias names. Bappa, Raja. Milord, these are alias names. Milord, Neil is the name, Milord, by which the local people used to call him, Milord.
Bappa Raja is not same person, Lordship.
Issue. No, not this one. The petitioner says that he is in custody for 235 days. Stop. 235 days. Stop. He has been falsely implicated in this case. Stop. Uh, he has no connection with the alleged crime. Stop. He prays for bail. Paragraph. We have seen the material in the case diary. Stop. There are prima facie, there are incriminating evidence against this petitioner. Stop. He appears to be the principal accused. Stop. The charge is of murder. Stop. Paragraph. On an assessment of the nature and gravity of the allegations and the possible extent of complicity of the petitioner in the alleged offense, comma, we are not inclined to allow the petitioner's prayer for bail, comma, at this stage. Paragraph. However, considering that the petitioner is in custody for some time, comma, we request the learned trial court to expedite the trial to the extent possible and conclude the same on an early date.
Great.
87.
87.
87.
I am for the state.
It's allegation under section, the principal allegation under section 302 Lordship. So the petitioner is due custody for 1 year, 80 days or for 14 months, 10 days, 11 days, as of today. But the charges have been submitted against 6 persons, you have been released on bail by the coordinate bench of thereafter, the trial has been initiated and till date, four informal witness has so far been examined and another 4 informal witness has also been examined. Total 8 informal, total 8 witnesses have been examined so far. What is the allegation? The allegation is this.
No, Mr. Shah, 13th May, you have suffered a rejection.
Yes.
On merits, yes, we understand it's a renewal, but one of the grounds is that there's every possibility of you threatening witnesses. What not instance? Yes.
No, the co-accused statement, the co-accused relative, this is not mine.
They are the friends, all.
Okay, what are the allegations against this person?
Actually, my lord, think that this is case of the brutal murder.
No,
But trial is a whale swing, my lord. And my lord, 15 December, last week witness yet to be examined. So
Last witness.
last week,
15 December.
15 December.
Last formal witness or last witness?
Witness. Civil has been already fixed, my lord. Trial has been whale swing, my lord. And my lord, deposition has been completed.
Rejection,
Or
rejection.
one eyewitness has been totally, that is crystal clear from the deposition from the one eyewitness. Gopi, the present petitioner's land has been trespassed, my lord. No question.
We have heard enough, Mr. Shah.
I am on the ground, I am I am in a debilitated condition because I am currently suffering from pancreatitis. No, why I am telling you?
We'll make all arrangement for treatment.
He has been so fragile in court, but he could not even produce before the court. The medical officer has furnished a report to the magistrate even. The trial court. The copy is also, the copy is also there. I am also annexed it. I am also annexed it. He is tuberculosis patient, pancreatitis, he is developed a stone in the pancreatitis. Everything is on record. The trial court has been given a report by the medical officer of the jail. They are also in the
Very well, you file a report regarding the health status. It will only delay matters. File a report. The petitioner renews his prayer for bail and it will go to the next circuit. The petitioner renews his prayer for bail, which was rejected on merits on May 13, 2024. Stop, 24 in CRM DB 212 of 2024. Stop. He says that he is suffering from serious ailments, including pancreatitis. Stop. He should be granted bail on that ground. Paragraph. We have seen the material in the case diary. Stop. Prima facie, there is sufficient incriminating evidence against the petitioner. Stop. Further, learned APP tells us that the last schedule for examination of witnesses has been fixed on December 5. Stop. Trial is likely to conclude on an early date. Paragraph. However, since medical ground has been urged by the petitioner, let the state file a report through the concerned correctional home, through the superintendent of the concerned correctional home, as regards the health status of the petitioner. Paragraph. List the matter once again before the next available circuit bench. Listed. Next circuit bench from 25th November.
Lord, 88, I am for the state. Lord, the last item 86. Lord, his co-accused is 88, Lord, who was hired by the principal accused. Lord.
Oh. If you ask us to apply mine on merits, we will not allow you to withdraw. Decide. Not pressed.
Today evening, we will receive the case diary. Kindly make it not today. Kalke.
91.
Thank you. I am appealing for this.
Case of allegation that dispute regarding immersion of good oil between friends. Lordship, why I am making this application? Kindly sees the FIR which I have annexed in page 9 of my petition. There are 10 accused persons named in the FIR, and in page 11, the role attributed by the 10 accused persons are there.
Page 11.
Page 11, page 10. Page 9 is the FIR, first page. The name of 10 accused persons are there. And in
How long you are in custody?
Lordship, my name does not appear in this FIR.
How long are you in custody?
Lordship, 2 accused persons were arrested on 22nd May, and another is 3 accused persons, and another is 24th May.
Not even few weeks.
Lordship, but
Investigation is
Okay, the victim is released from hospital.
But injury report says so.
Yes, injury report.
Type of injury is simple.
between friends.
No. Question is whether the injured is
Discharge.
discharged.
Page 3 and 6, madam. 14th discharge. 14/10. But incident of 13/10/2024. FIR on 15th of October 2024.
Yes, what are the allegations against this petitioner?
As per FIR, madam, these petitioners are not named in the FIR. Subsequently, madam, the 161 statements of the
No serious injury, it appears. And idol emulsions, all friends.
No weapons recovered also?
No.
Charge sheet, the investigation is going on. They will cooperate fully with the investigating officer. The petitioners say that there are several accused persons. Stop. They were not named in the first information report. Stop. The incident was a dispute amongst friends relating to immersion of Durga idol. Idol of Ma Durga. Idol of Ma Durga. Stop. They will fully cooperate with the investigating officer if released on bail. Paragraph. Learned state material in the case diary. Stop. We have seen the injury report. Stop. There does not appear to be the victim does not appear to have sustained any grievous injury. Stop. Paragraph. Considering the nature of the allegations and the gravity of the alleged offense and the circumstances in which the alleged incident took place, we are of the view that further custodial detention of the petitioners may not be necessary so long as they fully cooperate with the investigating officer. Usual bail data conditions, right?
This case, my lord, your lordship was pleased to heard the matter that on earlier occasion, one bail application was allowed by the Honorable Coordinate Bench. But that is not within the knowledge of the petitioner, and they subsequently filed the matter again. And the matter was discovered. And we were directed to file show cause as to why our earlier bail application will not be cancelled. We have filed our affidavit by our show cause by way of affidavit. If your lordship kindly take some pain to peruse the paragraph number 2, 3, 4, and 5 of my affidavit, your lordship will find that due to some miscommunication from the end of the client and also some response,
The deponent, that is the.
that is different. Different.
Two applications.
Two applications. There are all of the full-blooded brothers, and so far my responsibility I also cannot escape. In both the cases, I was the contracting lawyer. I am very fairly submitting, but I did not check that was allowed on earlier occasion or rejected. I am very fairly submitting. Apart from the responsibility of the petitioner, I was also.
Why are you saying you're fairly submitting? Do you ever submit unfairly?
No. So, well, actually, it is also my unintentional mistake. I did not check on the website.
And that is why the rules has been issued against you.
Yes, sir. What do you say?
Your lordship kindly consider the order.
No, actually.
Order sheet itself speaks.
No, actually, on the basis of the submission of the state authority from the city that the order.
Yes. They have obtained bail.
Yes, yes.
Thereafter, they file another application.
Yes, yes, yes.
Suppressing the.
No, that is not intentional suppression.
That is called suppression.
Yes, that is the.
Intentional or non.
That is the negligence. Okay, that is. the-
Negligence.
Okay.
You tell us one thing, what will they gain by doing this? They would run the risk of losing the benefit of anticipatory bail. Why would they consciously or deliberately do it? We accept the explanation, close the matter there. Hey, affidavit ta kothay? বন্ধ করে দিচ্ছি। এই As noted in our order dated November 8, 2024, the petitioners have filed an affidavit in response to the rule issued by a coordinate bench on October 5, 2024. Paragraph. The reason why the rule was issued is that suppressing that the petitioners have had earlier obtained an order of anticipatory bail, a second application for anticipatory bail was filed. Stop. Paragraph. The explanation in the affidavit is that it was due to an oversight that this was done. Stop. Unconditional apology. We say unconditional, but you know what the affidavit says? We conditionally tender apology.
No, my lord,
That is what the affidavit
that is very
says.
typographical mistake, my lord. Maybe condoned, my lord. It is typographical mistake, not by.
Unconditional apology. Stop. For the mistake, unconditional apology for the mistake. Stop. Paragraph. We accept the explanation of the petitioners. Stop. We find that the deponents of the two applications are different. Stop. The petitioners would not stand to gain anything by filing a second anticipatory bail application when they have already obtained anticipatory bail. Stop. Hence, we close the matter.
Grateful, I'm get.
We close the matter, the rule stands discharged. এই রুলটা কি আলাদা নম্বরই হয়েছিল? তাহলে ওইটা whatever the number is stands disposed of.
Ran to disposed of. Restored to file.
Item number 124.
Yes. Lord, I am for the petition in this case. Lord, I am for the petition. Lord, made please your option.
State.
Mr. Chakraborty, Nila Chakraborty's state, he has certainly fallen ill and.
Fallen ill? Nothing serious, we hope.
Nothing serious.
Not today.
125, I am appealing for the petitioner.
I am for the state.
125. Oh, I am 126.
125. 126. Abhishek Sharma.
126, I am for the petitioner. My lord, allegations under section 20B2C of the NDPS Act, my lord. My lord, this is the second application, my lord. My lord, initially it was rejected on 3rd of July 2023. Now, my lord, change of circumstances is this, my lord. The owner of the vehicle, my lord, he has got the anticipatory bail on the ground, my lord, since he is the owner, so he has nothing to do with the commercial vehicle. The petitioner is the driver. Lordship, the contraband article has been seized from the secret chamber of the vehicle. My lord, that cannot be done, my lord, without the consent of the owner. Secondly, my lord,
Considering the case diary, the order was rejected, the application was rejected.
rejected. And now, my lord, what happened in the meantime, owner has been granted anticipatory bail on the ground that since he is the owner, he is not attached to the this offense, lordship. But what happened, my lord, the seizure has been made.
Let us see that order.
Yes, lordship kindly comes to page 10 and 11. Now, my lord, that owner has antecedent, my lord, he is entangled with another NTBS case somewhere at Patna, lordship. So not that he has the clear image, my lord. And he has got the anticipatory bail. The petitioner before your lordship is the poor driver. So, my lord, I am seeking the anticipatory bail, lordship.
Eight is the last rejection.
Page 10.
Page 8. No, page 8, lordship. Page
Last rejection, your last rejection.
My last rejection is page 8 and 9.
Lordship, it was rejected by lordship.
Oh.
Lordship rejects it. Lordship, now owner of the commercial vehicle, he sits in some other
Correct,
place and
correct,
it is
correct.
driven by the driver.
But he has the anti-slip
You want to
clause.
suffer a second rejection? We are happy to.
My lord, in that case, next circuit.
No, no,
No,
no.
my lord, I am withdrawing in that case.
They do that if you want to. Not pressed.
Grateful, your lord.
127.
Commercial vehicle owner.
Lordship, I am for the petitioner.
127.
Yes.
Lordship, allegation under section 126, subsection 2, 118, subsection 2, and 109 of
PNS.
IPC, Lordship,
I-
IPC,
IPC.
corresponding to section 339, 321, and 307 of Bharatiya Nyaya Samhita 2023, Lordship.
I think it's just the other way round. Ulta bollo.
Lordship, may I proceed?
Attempted murder.
Yes, you are named in the FIR.
Yes, Lordship.
You are named in the FIR.
No.
Yes, what are the allegations?
Yes.
Lordship,
Previous should be.
Lordship, may I proceed the alleged fact?
But I have already informed the investigation agency to collect the injury report. There is no injury report.
When will you get?
Whether this person was admitted or discharged.
Yes, mother.
This person, the victim was admitted to
But
hospital.
2 days
Discharge.
he was admitted on the concerned hospital and thereafter he discharged, madam.
Discharge.
The certificate is there, madam, but there is not certainty of grievousness or.
No, certificate is there. Yes, where is the certificate?
No, madam. Injury certificate.
When
Medical report is 18 and 20. Page 18 and page 20.
That means this person was admitted.
Yes, madam.
That much.
Yes, yes.
Okay, there is no report.
When do you expect to gather the report?
But I have already informed the concerned police.
Shall we
station
keep it
collection.
on Thursday or tomorrow?
Difficulty is that, my lord, police authority has informed me that repeated times they are visited the place for the collecting the injury report, but the medical doctors are not turned down and they are not giving the report.
Which hospital will give a direction?
That's one I'm asking, my lord. Kuch Bihar, my lord.
MGN hospital.
But medical is there, madam, but kindly page 18 and 20, madam. Page 18 and 20. Pundibari, the hospital is.
MGN Medical College and Hospital.
Yes, yes. Yes.
Statement of the victim is recorded.
Yes, madam. Page report 164, yes, ma'am, like page 30.
Page 36.
Yes, madam.
Victim statement.
Yes, madam.
This is the 164.
Yes, madam, 164. The CMOH.
Injury report.
CMOH, which we are.
What is it called? The injury report or medical report?
Injury report. Injury report.
Hey, dekho na. The chief medical officer, comma, of Kuch Bihar district. No, Kuch Bihar district is directed to ensure that the injury report in the present case is placed before us on Porshudinit. Right, the paragraph. Let this order be communicated immediately by learned state advocate to the Chief Medical Officer, Kuch Bihar District. Stop. Paragraph. This matter will be listed on 14 at 10:30 a.m. Marked 10:30 a.m.
কি বলছে?
128. Well, I'm for the petition.
State.
I'm happy.
Well, allegation under section 448, 325, 307, 506, 34 of the Indian Penal Code, my lord. There are 20 accused persons before your lordship, my lord. FIR was registered against 28 accused persons, my lord. Well, Alice incident on, my lord, 7th July of 2023 and 156(3) application filed before the learned magistrate on 22nd December of 2023. Near about, my lord, 5 months delay, this 156(3) application was registered, my lord. After 5 months, my lord, there is a political enmity. The written complaint says so, my lord. The political dispute, for this reason, this false complaint was lodged, my lord.
Yes, injury.
This is the injury report. Victim was admitted in hospital on 7th of July 2023 and discharged from that hospital on 18th July 2011. That means
11 days.
11 days. 11 days.
Mission hospital.
Yes.
Private hospital.
No. Then
Private nursing.
then he has to go to Delhi and Nepal for further treatment.
Okay, where is the victim statement?
Yes, page 31.
He names all these persons.
Especially petition number 6. Petition number 6 here.
Let us see.
Especially petition number 6 here in Nurul Islam.
Acha.
He is the principal assailant as per the version of the victim.
We won't give him.
All rest persons also named, but he is the principal assailant.
After 5 months of this incident, this complaint, madam.
Yes, mother.
For 5 months of this incident, there is no government, whether he is treated at government medical college or hospital, all are private hospitals.
Investigation pending, mother.
Full covered.
161, my lord. Page 31, my lord. 161, my lord. Grateful, sir. Lord, 1 day's accommodation.
130.
Lord, days accommodation.
130?
Due to schedule.
31.
I'll get that.
131.
State.
But offense under section, my lord, was 137 surplus to 140 surplus 3 of the BNS file. And corresponding to 363, 365, 109 of the Indian Penal Code. But in this case, my lord, the principal accused is Raju Sheikh, but has allegation is had kidnapped the granddaughter of the
De facto
complaint. But we are the family members of the Raju Sheikh, principal accused. And petitioner number 1 is the grandmother of the principal accused, 64 years. And petitioner number 3 is the grandfather of the principal accused, aged about 69 years. And petitioner number 2 is the mother, and 4 is the uncle, and 5 is the father of the principal accused. And they are still they are absconding.
Yes, what is the statement of the victim?
But victim did not recovered yet.
Oh,
Both of them
then
have
how-
fled away.
Then at this stage, it is very difficult. If the victim is not.
161 statement is there, my lord, but
Yes.
statement of the victim girl is not.
No, 161 statements are there. So with regard to the female accused persons, are there custodial interrogation necessary?
Yes, my lord, they confine the minor girl in their own house and they refuse to return the,
Charge sheet has been filed.
no, my lord.
Investigation should say.
It is a preliminary stage of investigation. The girl was only 16 years old.
Correct.
When she went to
Principal accused and the victim both are fled away.
if your lordship kindly see at page 18,
We are the aged
161
grandfather and
statement
mother.
of grandfather of the victim.
We are aged grandfather and mother, my lord. Grandfather is about 70 years old.
Page 18, page I'm grateful to your lordships. 134. I'm from state.
No recoveries. State. No recovery.
My lord, actually he is lucky enough to fled away from this spot, not recovered from his position.
Caesar list doesn't mention him.
No, another request has been implicated.
Please. How long in custody? Oh, anticipatory. Anticipatory.
Submitted showing him absconding.
Judge is absconding.
From the and lucky enough to fled away at
Wait,
the
wait,
time
wait,
of the
wait.
incident.
The petitioner says that there was no recovery of contraband items from him. Stop. He has been implicated on the basis of statements made by co-accused persons. Stop. He is fully prepared to cooperate with the investigation, comma, if any, further investigation, if any. Stop. He prays for anticipatory bail. Paragraph. Opposing the prayer, comma, learned state advocate says that the petitioner fled from
Fled, Your
this
Lordship.
scene,
As per 160 statement.
fled from the place of Caesar. Place of Caesar. Stop. His complicity in the crime is evident from the material on record. Stop. Paragraph. However, he admits that there was no recovery from the possession of the petitioner. Paragraph. On an overall assessment of the material on record and considering that charge sheet has been filed upon completion of investigation, comma, we are of the view that immediate custodial interrogation of the petitioner may not be necessary, comma, so long as he is prepared to cooperate with further investigation, comma, if any.
I'm for the statement. This is the opinions of his lordship.
Sorry?
I have the objections, Lord. In this case, I am not taking Yes.
Adding section 300.
He succumbed, the victim succumbed to the injury.
Yes.
One is Hazrat Ali and Anwar Ali. There are two accused people in our
One has been granted bail.
Hazrat or the arrested.
Hajrat is before us.
Yes, what are the allegations against these two persons? Lordships, হযরত আলী হঠাৎ করে আমার আব্বার গলা চেপে ধরেছিল, that involvement, and this petitioner, your lordships, তখন হাফিজুলের মা, হাফিজুলের একটা মোটা কাট petitioner here also.
No, Hafizul is not the petitioner here. Petitioner is Hazrat and Anwara Bewa.
Yes, lordship. Anwara Beva also involved in this. Okay, let us see. Lordships. Heading section 302, your lordships. Anwara Beva.
How long after the incident he died?
2 days on your lordships. Lordships, kindly see the medical lordships. Actually, I have if they will get bail, they will be highly encouraged to commit such type of offense, your lordships.
Hafizul seems to have dealt the blow on the head.
And Hazrat Ali and Anwar Bewa. Here, your lordships, Hazrat Ali, assert your lordship.
Hafizul dealt the blow, the statement that you are showing us.
Yes.
And Anwar Bewa also helping to commit. Common intention to kill.
Yes, principal.
And a hit on the head of the
Principal accused is on bail.
Lordship kindly appreciate medical report, your lordships.
We will only grant to the lady, not
Yes, please take note.
advocate for the leave. I mean, correct the cost.
Address section 302.
For the petitioner and learned advocate for the opposite for the state of the municipal learned advocates. Produce the materials in the case diary. Learned advocate for the petitioner submits that his clients are falsely implicated in the instant case and the principal accused is already enlarged on bail. Learned advocate for the opposite party objects the grant of bail and submits that the offence is heinous in nature and the petitioners are also involved in the offence. Upon perusal of the case diary, mainly the statement under section 164 CRPC, we are of the view
Recorded by card statement.
yes, recorded by statement 164 recorded.
Victim's daughter or son.
Lordships, 164 to page 130.
Yes, yes, but who made the 164?
Lordships, name of the kindly.
Yes, granddaughter of the victim, probably.
Yes.
Abbar was daughter of the daughter.
That is daughter of the victim. We are of the view that in the interest of justice, custodial interrogation of petitioner number 2 is not required. Thus, petitioner number 2 should be granted anticipatory bail. Thus, we allow the prayer for anticipatory bail made by the petitioner number 2. Hence, it is ordered, only judge condition. Police নিয়ে করাটা থাকবে না।
মহিলা বলে থাকবে।
The prayer for anticipatory bail made by the petitioner number 1 stands rejected.
That's rejected since from the statement of the victim's daughter, it appears that he was an active assailant.
Allegation under section 143, 448, 326, 307, 427, and 506, Lordship. In this case, Lordship, principal accused, namely Javed Mir and Maulana Shulkar, who should fire Lordship. They granted bail by the trial court and all other co-accused persons enjoying the liberty of bail.
Case of 2020, Malad. First of all, Malad, I have underlined some names and portion of the 161 statement of the victim, Malad. Kindly see. Here in petitioner number 1, 2, and 3.
Rotish.
1, 2, and 3. Petitioner number 1.
Okay, you have underlined the name of the
yes.
persons involved.
Yes.
Moqsadul. Falun. Falun. But where is Sanjay Sarkar?
Not named in the 161 statement of the victim, Malad. Kindly see the next page. Next page, Malad. The photograph of the victim, Malad. And 8 days he was in admitted in the nursing home at Siliguri.
307.
307. Bullet injury is there. Though as per version of the 161 statement of the victim, these persons are not fired any.
Who fired?
Fired another person.
He is on bail.
So all 4 persons did not.
One who fired is on bail.
Bail or anticipatory? Bail, madam. This is anticipatory.
No, is there any overt act on behalf of this?
Yes. Kindly see the
That lines, my lord. Wherein, my lord, I have underlined the names.
We can only grant to Sanjay.
Yes, ma'am.
Esho. The petitioners are 4 out of several accused persons. Stop. The charge is of attempted murder. Stop. The petitioners say that they have been falsely implicated. Stop. They pray for pre-arrest bail. Paragraph. Opposing the prayer, learned State Counsel draws our attention to the statements of witnesses recorded under 161.
Statement of the victim.
Victim, statement of the victim.
Under section 161.
Recorded under section 161 CRPC. Stop. He squarely names the petition numbers 1, 2, and 3 as some of the assailants who inflicted injury, grievous injury on him with the help of a DAW, D-A-W, DAW with inverted comma. Stop. We have seen the photographs of the victim with his injury and the injury report. Stop. He suffered grievous bodily harm. Stop. In view of the aforesaid, the the prayer for anticipatory bail of the petition numbers 1, 2, and 3 is rejected. Paragraph. However, insofar as the petitioner number 4 is concerned, the victim did not name him. Stop. There is also no such criminal material in the case diary as would justify rejection of his prayer for anticipatory bail. Accordingly, it allow হয়ে গেল, huh?
My lord, prior to start, my lord, they have sent the injury report, not visible, not at, learned. It's a instruction is required for CUMH lordships. They have sent a report, high care type of not known, this type of your lordships. So although they have written that they are the blood, whatever.
So what do you want? Tell us.
Report is required, your lordship.
Injury report.
Yes, your lordship.
Whom should be direct?
They have sent. Not simple, cut injury, but not known. Type of injury not known. They are the expert. How they do all these things? And we should refer. No, simple injury. Simple, there is a 4 medical report, simple injury. But others are not simple.
He is saying simple injury.
Simple, there is a 3 injury report. 326. 326, your lordship.
No, 307.
307. That's why I'm. There is a 3 medical report, your lordship. But one. Kindly see, my lord.
Case is there. Any counter case?
Counter case was registered. Who also suffered injury? I also have it. Charge sheet submitted. Nature of injury appeared. I will cooperate in maybe interim bail.
Interim bail.
Case was registered on 2020.
Yes, tell us.
You want yes, clarification. Yes, regarding the report, my lord.
Tomorrow, not today. 138 state. State,
140, my lord, Niloy Chakraborty is there, my lord.
not today.
141. 141 state. 142.
My case is under section, my lord, 325, 379, 506, 120B, my lord, 412 of the Indian Penal Code. I am claiming the parity, my lord. Kindly see page 13, my lord. All the accused person granted bail and anticipatory bail. My lord. Lastly, my lord, on 4th October 2024, one person got anticipatory bail. And petitioner is on same.
All persons, only one petitioner.
No. Charge sheeted person.
How many charge sheeted persons?
Charge sheet submitted 16%.
Yes.
15% got bail anticipatory bail.
Yes, what are the allegations under 395?
Actually, they are,
395.
they are
395 is also there.
Yes. It's nothing.
How he pays.
they are trying.
Charge sheet submitted.
Yes.
Charge sheet submitted.
Oh, let us see 395 allegations.
My lord.
395 allegations against this person.
Yes, yes. Actually, his name is not reflected in the
FIR.
FIR, but subsequently his name is came up after investigation, your lordship.
That is from the co-accused person.
Yes.
No. From the 161 statement.
Yes, 161.
But is that correct? Is it correct that all other accused persons charge
Yes,
sheet
yes.
have been granted bail,
Granted bail.
anticipatory bail?
Yes.
How does he stand? How does he stand on a different footing?
Both are
Same footing.
all are trying to grab the mission as the property.
Yes.
Ramakrishna mission, that was charitable. They are trying to make a false deed and trying to grab that property, and subsequently
It appears that all other accused persons have been granted bail, oblique anticipatory bail at different points of time. Stop. Investigation is complete and charge sheet has been submitted. Stop. It does not appear from the material in the case diary that immediate custodial interrogation of the petitioner is necessary. Paragraph, accordingly, comma, in spite of objection raised by learned counsel for the state, comma, we are of the view that we are inclined to grant anticipatory bail
versus condition may
to the petition. Yes, yes. All the usual conditions.
Yes.
4 PM fixed matter. Item number 54.
Sir, 54, my lord, in this matter, my lord, I am appealing for the applicant.
Sorry? No, I know, but then 4 o'clock, Mr. Dotto has come all the way from Calcutta. You think the time will be left? If time is left, we'll take it up. Go.
My lord, in this matter, my lord, I am appealing for the applicant.
But I appear on behalf of the petitioner in the matter.
I appear for the private respondent.
And I am filed an application for addition of party, my lord.
Before your lordship open the brief, may I tell your lordship in very nutshell?
Can we have a little less noise, please? Yes.
Before your lordship open the brief, my lord, may I tell you lordship in nutshell? My lord, here the dispute between the petitioner and the respondents were relating to correction of a record of rights. My lord, ultimately the matter went up to the tribunal. My lord, for the purpose of conducting this litigation, my lord,
we had appointed one person as our power of attorney. Subsequently, and during the pendency of the proceedings, but we had revoked that power of attorney by registered deed, and we had appointed another person as a power of attorney on our behalf in his present state. But this revocation of power, appointment of new power of attorney, everything were published in the newspapers. And in addition to that, individual letter was also served on the person in whose favor the power of attorney was revoked, and he had also accepted that. After that, my lord, in between, my lord, the parties had resolved the dispute between them with regard to this correction of the record of this. My case was before the tribunal that my landed friend's client had got their name recorded surreptitiously without any knowledge and notice of mine. So that was the crux of the dispute.
Your case before the land reforms officer.
Yes.
Your objection before land
Reforms officer.
So being agreed by that, you move before the district land reforms.
Yes,
officer,
yes.
Definitely.
And thereafter,
Before the tribunal.
Before the tribunal, blessed with us. So my lord, ultimately, it was resolved between us. So I went to that tribunal and I filed an application before the tribunal for withdrawal my proceeding. Only ground that we have resolved the dispute, so we do not want to proceed with the matter. The tribunal did not agree to get this matter withdrawn and did not allow me to withdraw the matter at the instance of the advocate who was appointed by my erstwhile power of attorney holder. And the tribunal said that you file your affidavit, this, that, etc. And the matter was made returnable in 2025 in the month of August or somewhere. So, well, I have come before your lordship by this writ petition from that impugned order. Well, may I just show your lordship, before I take your lordship to that impugned order?
Only thing, Mr. Dotto, can this writ petition, which seems to be involving some factual aspects, be disposed of without inviting affidavits?
Because my landed friend is appearing for the respondent.
I am appearing for the intervening person.
I will come to the intervening aspect later first. Now, my lord, so far
your grievance was against this respondent, private respondent.
Absolutely. I do not have any grievance against anybody.
So we can
Now, my lord, is suit executed the deed by power of attorney holder. Now he is saying that the power of attorney holder is no authority to execute those documents. Suit is pending. Nothing has been stated. After filing of the suit, this story is come up.
My predicament, my clients who were the original owners of the land all the while got involved in these processes of litigation.
Sir, you are really not opposing the writ petitioners? Correct. We have understood. You were agreeable to the withdrawal of the proceeding before the tribunal.
And
my lord, so far.
May I speak,
We are. I have not yet completed, brother. Please let me complete. All of you will have your turn.
And for one set of interveners, but our stand is that the power of attorney which was executed, that was not a simple power of attorney, it was coupled with it. Because it's extremely well aware with the principles If it is coupled with interest, it becomes irrevocable. Well, that revocation was absolutely nullified.
Your locus standi with regard to that
That's
power
why I
of
have, the can two is.
But they have filed suit against me.
very well.
You enforce the suit there.
Record, we are not going into the merits of the suit, nothing.
Discretion.
Whatever liberty will be there, you can take that. But your locus standi with regard to this correction of
Absolutely,
record of right.
absolutely.
Yeah, we have to be.
Correction of record of right.
Already Millard, a third party interest has been created.
Whatever it is, we are not.
We are not going into
They
the
have been
merits.
submitted.
We are making some observation, sending it back to the tribunal, with a direction to prepone the date of hearing and dispose of by the end of January, 2025.
Let the intervenants be hard over there.
You will be entitled to approach the tribunal. The tribunal, if it deems it's proper, it will hear you. If not, it won't. That
But
will say nothing.
they have, Madam Kylie, they have filed the independent suit against me. The suit for specific performance.
Anyway, tribunal.
And after filing.
Mr. Dotto, rightly or wrongly, they have filed applications before the tribunal.
Yeah.
Now it's up to the tribunal to decide whether it will entertain the application. Yesho.
Enjoy the interim order also.
Yesho. The petitioners are aggrieved by an order of the Land Reforms Tribunal, Land
Land Reforms and Tenancy Tribunal.
Land and Land Reforms Tenancy Tribunal, bracket LRTT, WBLRTT, West Bengal Land and Land Reforms Tribunal, WBLRTT, comma, which is interim in nature, comma, whereby the tribunal has not allowed the writ petitioners to withdraw their original application at the instance of a learned advocate who the writ petitioners say had been earlier appointed
By the earlier power of attorney holder.
by their earlier power of attorney holder. Stop. The tribunal has posted the matter for final disposal after exchange of affidavits in sometime in August.
March 2025.
Oh, you said August. That is
I
right.
made a mistake.
In March, 2025. Stop. Paragraph. The short, the material facts of the case insofar as the same are necessary to record are that the writ petitioners had a dispute with the respondents herein regarding correction of record of rights pertaining to certain plots of land. Stop. The dispute was taken before the land reforms officer, comma, then before the DLLRO, District Land and Land Reforms Officer, Purta diye diyo, and ultimately before the WBLRTT. Stop. During the pendency of the original application filed by these writ petitioners, comma, they resolved the disputes amicably with the respondents herein. Stop. Accordingly, they approached the tribunal for withdrawal of the writ petition. Stop. The tribunal has refused to do so as recorded above. Stop. Paragraph. We prima facie do not find why the tribunal should not allow the writ petitioners to withdraw their writ petition. Stop. After all, comma, they have the carriage of proceedings. Stop. They had approached the tribunal with a certain grievance. Stop. Now they say that their grievance stands redressed and they don't wish to proceed with the writ application, with the original application. Stop. Therefore, comma, unless there are other compelling reasons, comma, it will not be lawful for the tribunal not to allow the writ petitioners herein to withdraw their original application. Paragraph. Mr. Ghosh, learned advocate, appears for certain interveners. Stop. He says, give the name of your client in the order. He says that the power of attorney that was granted earlier by the writ petitioners in favor of Jayanto Dhar was not a power of attorney simpliciter. Stop. It was a power of attorney coupled with interest in land. Stop.
I dispute that.
This, therefore, the tribunal should hear them before taking a final call on the original application or before allowing the writ petitioners hearing to withdraw the original application. Stop. We are told that Mr. Ghosh's client has filed an intervention application before the tribunal. Stop. The tribunal will deal with the same in accordance with law. Paragraph. Mr. Dotto, learned senior advocate representing the writ petitioners herein disputes that the power of attorney that was granted in favor of Jayanto Dhar was coupled with an interest in land or any kind of grant. Stop.
And in any event, they have filed a suit against me individually.
He further says that Mr. Ghosh's clients have filed a suit against the writ petitioners, which is pending before
the district court, my lord.
district court.
Civil judge?
Civil Judge Senior Division Shiliguri. Stop.
For specific performance.
For specific performance of sale of the land in their favor, sale of the land in question in their favor. Paragraph. We are not inclined to enter into the merits of the disputes between
In the meantime, my lord, I have also filed an application for intervening application, my lord.
Why?
Because there is a suit and this power of attorney
He has also
He has also filed a suit.
Very well.
My lord, the days will go on, but
We are
another
not-
application will come.
Otar aage lekho. Mr.
It is appearing to my lord.
Parthu Pratim Roy, learned advocate, representing, give your client's name.
Yes, my lord, the intervening application is appearing CN number 1 of 2024.
Oh, you keep, dekhe now. Has also filed an application for intervention in this writ petition. Have you also filed an application before the tribunal?
No, my lord, only here.
Stop. We are not inclined to entertain that application here. Stop. Mr. Roy's client will be at liberty to approach the tribunal with an appropriate application, and it will be for the tribunal to deal with that application in accordance with law. Paragraph. We are not inclined to enter into the merits of the disputes between the parties. Stop. The matter is pending before the tribunal. Stop.
My matter is no more pending, my lord. It is over.
Yes, pending.
Oh, that is 25th. Correct.
Stop. Factual issues are involved which may not be easily adjudicable in the writ court. Stop. We request the tribunal to decide the original application in accordance with law, in the light of the observations made in this order, after granting an opportunity of hearing to all the parties that the tribunal deems fit and proper.
Grateful, Your Lordship. Grateful, Your Lordship.
If you like, you can take the 6:45 flight.
But is it your lordship pleasure to
Prepone.
fix any time limit?
Yes. Paragraph. In view of from when is this matter pending? Before the tribunal, when was it filed?
20th March,
This,
March 25.
this year.
25.
When was the original application filed? Since the original application is pending from March, 2023, we request the learned tribunal to prepone the next date fixed for hearing and make all endeavors to dispose of the original application by the end of January 2025. Original application.
Original না
যা এখানে রিট যা আছে এখানে সব ডিসপোজড অফ। হ্যাঁ, কল করো অনিরুদ্ধ যদি থাকে দেখো।
But I can't catch the flight now.
You can actually, because it takes 1 hour 10 minutes at the most. But stay back, I suggest, because the weather is very pleasant.
I don't want to miss evening.
See the next one, Lordship will take up my other side is.
দেখো কোনটায় বোথ সাইজ আছে দেখো।
The principal charges are.
Where is the state?
The principal charges under section 354 and 315 of the Indian Penal Code. Now, Lordship, the petitioners before your Lordship against whom 315 is not attracted. Now, Lordship kindly comes to page 13, where my lord, the one of the accused persons, he has got bail, where the observations of the learned session judge has been given. My lord, Lordship kindly comes to page 13. My lord, I have gone through the statements made by the victim lady before the judicial magistrate. She has named 2 accused persons that they have physically assaulted her, for which her miscarriage took place. The injury report dated 11/7/2024 clearly shows that no miscarriage was done to the victim Ajima Khatun. So, my lord, no miscarriage happened. It is a dispute relating to the landed property, and both the parties, my lord, therefore, this allegation, this.
The periods with regard to 354 are there.
354 is there. Now, my lord, the charge sheet which has been filed, my lord, there is no 315 in respect of the petitioner number 4, 5, 6, 9 and 12 of my application. There my lord, against them the other charges are there, one of which 354. Now, my lord, and the order of the learned session court, my lord, the miscarriages has not been happened. So, my lord, 315 is
there against the
no.
the petitioner.
No, my lord, charge sheet is a very peculiar charge sheet. Here, my lord, the observation is such and such sections in respect of these petitioners, not 315. But ultimately, the charge sheet has been filed against all the petitioners, including 315. But my lord, the order sheet of the learned session court, while granting bail to the one of the accused, he said that there is no miscarriage took place. And my lord, the victim lady in her 164 statement has stated in respect of 2 accused persons.
This is the sessions tribal case.
Yes, your
315 is the session tribal case.
315 session tribal case.
My lord, Not page 87. Sorry, my lord, page 80. The statement of Ajima Khatun. Page 80. These are the medical, my lord. 2 pages are there, my lord, of the 2 victims. Page 80, statement of Ajima Khatun, and 87 is the Rama Begum. 80. Victim is page 80. Yes, 2 victims are there, my lord.
And dispute থেকে শুরু হয়।
Yes, so far this 164 is concerned, the present petitioner names are not there. Yes, that is page 80. And so far page 78.
87, 87.
87.
87.
That is-
Three names are there, my lord.
87.
Yes, my lord. Petitioner number 2, 3, and my lord, 11.
Which was stapled together, right?
Yes, my lord, charge sheet. Yes, my lord, between the
96. We can go to that 2,
petitioner number 2, 3, and 11 is there, my lord.
2, 3, 11, any direct when allegations against them causing the assault.
Yes.
That is 2, 3,
And 11. Petitioner number 11.
দিয়ে বাকিটা দিয়ে দাও।
Yes, please take down.
And 3 is Saddam. Saddam is mentioned
My lord,
in
2,
both. Yes, yes.
Aliyah Rahman,
Yes.
3, Saddam Hussein, and my lord, Haidar Ali.
ঠিক আছে।
Petitioner and learned advocate. So the opposite parties, those are represented, are learned advocate for the parties. That is the materials in the case diary. Learned advocate for the subjects that the petitioners are not involved in the case. And the allegations made against them are not considered. Learned advocate for the subjects that the two co-accused persons are on bail, and as the charge sheet is completed, the prayer for anticipated bail made by the petitioner be considered. Upon considering the materials in the case diary and the statement of 164 CRPC made by the victim lady, where allegations are made against petitioner number 2, Aliyah Rahman, petitioner number 3, Saddam Hussein. Yes, 2, 3, and 4.
And 11.
And
2, 3, 11.
And petitioner number
11, Haidar Ali.
11,
Haidar Ali.
Haidar Ali. We are of the view that it is not a fit case to grant anticipatory bail against the state petitioner. Thus, the prayer for anticipatory bail made by the petitioner stand rejected. However, with regard to petitioner number 1, 2,
1, 4, 5,
1, 4, 5,
5,
6, 7, 8,
6 to 10,
and
11,
12. No, my lord,
11, 11, 12.
10, and 12
And
12.
are granted anticipatory bail.
1, 4 to 10, 11, 12.
1, 4 to 10, and 12.
12.
I'm grateful, my lord.
Please, John, only send to you.
My lord.
I have been mentioning on the interview due to extreme medical emergency, this one time one. It is also the
Well, I had already mentioned the matter.
153, state is also.
All can't be taken up in 5 minutes. Medical ground, he said, let us see that. Mr. Vishwas, come back tomorrow. Medical ground may be more urgent than your.
I have a medical ground also. Actually, my lord, what happened? Why my urgency is that my elder brother had suffered a stroke, and my elder nephew is just 8 years old, lordship.
Who's,
The prob-
you mean the petitioners?
No, mine.
Oh, personally.
Personally. If I don't come tomorrow, my junior will be under great prejudice, my lord.
That is also a
Past
medical
grief,
ground.
my lord.
After them, then.
I have to
After
that-
them, I shall wait.
আচ্ছা দেখো অনিরুদ্ধটা কোথায়
230.
যাবো
236. What side is there? 236.
আমি পৌনে 5 থেকে তুলে দিব
I think 236.
ওটা হয়ে যাচ্ছে।
236. আচ্ছা আচ্ছা।
section of IP is 498A and 304B. Lord, the petitioner before your lordship, my lord, is the married sister-in-law and the husband of the married sister-in-law of the deceased lady.
They stay somewhere else.
Yes, my lord. They stay around 60 kilometers away from the alleged place of occurrence.
Charge sheet is submitted.
Charge sheet is not yet submitted.
Okay, and husband?
Lord, husband is in custody, my lord.
Oh, this is case of 1410.
My lord, my lord.
That case, my lord, at not, we have not pressed that case, my lord. Same, my lord, similar allegations are against them.
My lord, for the husband, my lord, it was not pressed. The husband is in custody.
They stayed somewhere
Yes, yes,
else.
yes, my lord. Yes, yes, my lord.
করে দিচ্ছি, দিয়ে দিচ্ছি। The charge is under section 490, 80,
85 and 80 of the NS.
sections 80/85 BNS corresponding to sections 498A and 304B, capital B, IPC. Stop. The petitioners say that they are the বিকাশ, প্রথমটা হচ্ছে বিকাশ। The petition,
Mother-in-law and married
the
Married sister-in-law and her
the
husband.
petitioner number 2, কেটে দাও, the petitioner number 2 is the sister-in-law, bracket like husband sister, bracket close, of the victim lady. Stop. The petitioner number 1 is her husband. Stop. They say that they reside 60 kilometers away from the house where the victim lady resided with her husband. Stop. They have no role to play in the alleged offense. Stop. They have been falsely implicated. Stop. Charge sheet.
Not yet submitted.
Pending. Paragraph opposing the prayer, learned state advocate says that investigation is in progress. Stop. There may be enough incriminating material against the petitioners. Stop. Bail should not be, anticipatory bail should not be granted. Stop. Custodial interrogation may be necessary. Paragraph. Having considered the facts and circumstances of the case and the fact that the present petitioners lived far away from the place, from the residence of the victim, we are of the view that immediate custodial interrogation of these petitioners may not be necessary so long as they cooperate with the investigating officer. Usual. No, you may not. Sorry. This has to be an end. But since you have waited so long, এনার মামলাটাকে কালকে যেখানেই থাক তুলে ওপরে তুলে দাও. This is the prize you get for waiting.
Grateful, my lord. আমাদের নোটিশ করব।
একটা সিডি আছে এটা অফ করে বলছি একটা সিডি